Your Lordship's indulgence.
Yes, sir.
If I may mention, item 4 from part 2.
Item 4.
Yes, Your Lordship. It's fixed for today, but Your Lordship, I have some personal difficulty. This can come up the week commencing 20th of July.
Okay. At the request of the learned counsel for the parties, list this matter again in the week commencing 20th of July.
Yes.
20.
May it please your Lordship, I seek your Lordship's indulgence in mentioning item number 18 of today's list.
18.
Yes, your Lordship, that is fixed for hearing. Your Lordship, due to personal difficulty, if this matter may be listed on the week commencing from the 20th of July, after the vacations.
It was a fixed matter, so give me a fixed date.
Your Lordship, if this may be listed on
For the petitioner, 23rd or 24th.
Okay, 23rd.
yes, your Lordship.
At the request of the counsel for the parties, list this matter again on the 23rd of July.
Much obliged, your Lordship.
Yes, sir.
May I please, Your Lordship, my lord, under my lord, unable circumstances, my lord, I am paying my lord one bail matter, regular bail matter, my lord, only calling for city, my lord, today unlisted date to be.
The unlisted, have you served copies?
My lord, I am being filed, my lord, within half an hour. Kindly, my lord,
Okay.
only will not take time.
We'll call for the only. See, he is asking only for CD, no interim.
Deep
Outstation. Okay, take it.
Your Lordship, with regards to part 2, item number 10, if this matter can be fixed on after vacation, Your Lordship.
Action.
Yes.
Okay, at the request of the learned counsel appearing for the respondent, that this matter be listed. You want a fixed date?
Let it be after vacation.
After vacation.
After the vacations.
Deeply obliged.
May it please your Lordship, I seek your Lordship's indulgence in mentioning item number 8 of the admission list, your Lordship. I've taken the consent of the parties, your Lordship. In this matter, your Lordship, even though this matter has been listed for admission hearing, I would like to be granted some accommodation to seek further instructions, your Lordship, because there is a correspondence in the affidavit which is dated March 2025. So I would like to get instructions as to what new development has been taken on the end of the PWD department as to.
Have you informed the petitioner?
Yes, your Lordship. The
I'm
petition.
for the petitioner, my lord.
When do you want it?
Let it be fixed on 21st of July, my lord, if possible.
Your Lordship, if it may be, if I may be given a tentative date, because again, if I'm seeking instructions, it has to be. It will take time for the concerned department to reply.
We'll
to
give
the
you
same.
1 week more, 28th.
Okay. Yes, your Lordship.
Leave your rights.
20th is fine?
Yes, your Lordship.
At the request of the learned counsel appearing for the respondents, with the consent of the learned counsel for the petitioner, list this matter again on 28th of July 2026, allowing the counsel for the respondents to complete her instructions.
Much obliged, your Lordship.
May it please your Lordship.
Yes.
I seek your Lordship indulgence in making a mention of part 2, item number 12, hearing column mile.
Item number
12, my lord.
12, yes.
Yes, I have taken the consent of the other parties, and if this matter may kindly be taken up after the vacation, my lord.
At the request of the learned counsel appearing for the parties,
And my lord, in the
list
meantime,
this matter again on again after the vacations.
yes, the interim order passed earlier may be
The
continued.
interim order passed earlier continues.
Obligement.
May I seek your Lordship indulgence in mentioning bail application number 58 and 59. It's not in the cost list. The main counsel for the petitioner is coming from Gauhati tomorrow. If the matter, we kindly list that tomorrow, your Lordship.
Okay.
Much obliged.
Yes.
I seek your Lordship's indulgence in mentioning part 2, item number 13.
Part 2, item number
13.
13.
Yes, my lord. My lord, as agreed by both the parties, I kindly pray this matter to be taken up on the 21st.
At the request of the learned counsel for the parties, list this matter again on the 21st of July,
Mashallah.
2026.
From motion list, item number 1.
May I please your Lordship, by this writ petition, the petitioner is challenging an illegal seizure or repossession of his vehicle by the respondent number 2. Then the petitioner had purchased his vehicle on 9/11/2022 from the respondent number 5 for rupees 37 lakhs approximately by availing loan from the respondent number 2. Then the purchased vehicle was insured with the respondent number 6, SBI General Insurance. And unfortunately, on 6/11/2024, that is after almost 1 year, the vehicle met with an accident at Darlak at Mamit district, and a police report was filed. An MVI inspection was also completed. Then the damaged vehicle was deposited with the workshop of the respondent number 5, Zauthon Auto Works, for repairs on 16/12/2024. And an advance of rupees 1,50,000 was also paid towards repair costs. Then a vehicle preliminary estimate was also issued by the respondent number 5. Then, due to the accident, the petitioner could not repay the loan installments as it is the primary source of his livelihood. Then a verbal request was also made to the respondent number 2, which was also agreement for moratorium of the loan. Then, despite the pending repairs, the petitioner received loan recovery notices for 3 occasions. Then, while awaiting the repair updates from the respondent number 5, the petitioner was shocked to learn that on 31/2026, through a letter from advocate and Anandan, that the vehicle had been seized and sold for rupees 7,50,000.
It has already been sold.
Yes, it has been already sold
Then?
without our knowledge. Then the seizure was conducted without seizure memo signed by the petitioner. Then
Now,
pre-intimation.
how does the read code, where does the read code come in, sir? Some private company is taking your vehicle, selling it off. Why should a read code interfere?
Because it is my primary source of livelihood.
Could
Then
be, but how can the read code come in? You had a contract with a private party regarding a loan.
yes, that
You have not repaid the loan. They have taken the vehicle. So if they have taken it without your consent against the law, it is a criminal case. And if you are asking
an
damages,
FIR
it's
was
a civil
also
case.
an FIR was also submitted by me, but a step was not taken for the repossession of.
Then again, the recourse is not read code. You have to go through proper channel. There's a channel.
Then-
You make a complaint to the magistrate. The magistrate does something. Is it not? They'll call for a report. They'll ask where is the vehicle, this, that, who took the vehicle, how they took the vehicle.
The loan agreement was also not provided to
Huh?
us. The loan agreement was also not provided
Those
to
are all
us.
civil disputes. How does the read code come in, sir? Why should we interfere in 226? Has the state done something? Suppose there's a private teacher and he's dismissed.
Because we have,
Livelihood gone. How will it come in? You have to show us how it comes in.
because your lordship, we have submitted an FIR to the Vivacon police
But
station.
if you have submitted an
Yes.
FIR,
But
is the read code supposed to look into it? What has happened to the FIR? Can we look into it? If there's an FIR, then you have to follow the procedure under the CRPC or now that, is it not?
but your lordship, there
What
is
can we do?
an authority by the Supreme Court also,
Says what?
by which the read code is also interfere with this
Sure.
matter. But I am not making that
Ah.
judgment. May you give me an opportunity?
Huh?
Yes.
This is one way of doing it. You say, I have got a Supreme Court authority, but I don't have it now.
With regard to ICICI Bank and the petitioner.
I do not have any. Huh? I don't think you'll succeed here, sir. You should go for better avenues.
My lord,
There will be a better litigation somewhere else.
give me a chance.
Now, please see
Yes.
your prayers.
Yes.
Which prayer can we grant? Tell us. One prayer that we can do. You are asking for a writ of mandamus on respondent number 2. Who is respondent number 2?
The Chola Nama.
How is it a state? You take a loan from him. How is it a state? What is the public discharge of duty that it is doing? Which public duty is it discharging? He is opening a business, you are going to buy a packet of biscuits. Biscuits are banned. When? Either we close it today or we close it some other day. Tell us.
Give me some other day, then I'll come.
Close it some other day.
Yes, yes.
After some
After
arguments in
vacation,
the
yes.
matter. The learned counsel for the petitioner has submitted that he would place before the court certain citations to show that the writ petition is maintainable. Stop. Allowing the accommodation. Place the matter again on 27th,
Yes, my lord.
27 July.
Yes. Oblige your lordship.
From opposition on column, item number 2.
Yes, sir.
May it please your Honor. The petitioner is aggrieved by the decision of the respondents in cancelling the recommendation of the selection committee made in his favor for promotion to the grade of professor under the respondents, Judge. The Mizoram University. Your Honor, the petitioner was promoted to the higher grade of associate professor with effect from 22nd of January 2019. And if I may take a lordship to annexure 6 at page 22, after his promotion to the grade of associate professor on 22/1/2019, he had approached the respondents for promotion to the next higher grade, that is the grade of professor, and his application was screened by the respondents. And at annexure 6, we have the screening made by the evaluation committee. And if your lordship will see, as per this, the screening committee had recommended him to be considered for promotion by the selection committee. Thereafter, your lordship, if I take your lordship to page 24, annexure 7, he was called for personal interview before the selection committee by the letter dated 21st of February 2022. Thereafter, your lordship, at page 25, we have the recommendation, the minutes of the selection committee at annexure 8. And this is dated 23rd of February 2022. Your lordship, the typed copy is at page 26, true typed copy. The selection committee had recommended him for promotion. If I may read from page 26.
Yes.
I'll read the relevant portion. The selection committee comprehensively evaluated the candidate, Dr. Rajesh Kumar, both on his profile, publications, and interview performance. On assessment, the committee has recommended the candidate for promotion from stage 4, associate professor, to stage 5, professor under CAS, Career Advancement Scheme, in the Department of Mathematics, Pachung University College, Mizoram University, from the date of eligibility. The candidate needs to publish 3 papers every year and apply 2 research projects compulsory every year, and needs to update biodata further. So the selection committee had recommended the promotion of the petitioner from stage 4 to stage 5. Thereafter, your lordship, suddenly things took a U-turn at page 27, annexure 9. Due to some complaint submitted by someone, a review committee was constituted by the university, which is at page 27, annexure 9. The Vice Chancellor is pleased to constitute a 4-member committee to review CAS applications for promotion in respect of Dr. Raghvendu Pathak, Department of Chemistry, and Dr. Rajesh Kumar, who is the petitioner before your lordship, Department of Mathematics, Pachung University College. So after this, your lordship, the review committee had again reviewed the selection made in favor of the petitioner by the selection committee And there, the review committee had cancelled the recommendation made by the selection committee and had stated that the petition is not recommended. As per eligibility criteria, academic and research score required is 110, which they said that I do not have the required academic
You had
score.
something 72.4.
Yes. So
So
then,
74.2.
yes. So the recommendation of the selection of the review committee was accepted by the Executive Council in its 60th meeting, and which is available at Annexure 11. It starts from page, the relevant portion is at page 36, Your Worship.
Oh, we've seen that.
Yes. So now, Your Worship, the dispute is very small. Whether the academic score of 110 is to be achieved by the candidate during the assessment period or during the entire career of his service.
Okay.
That is the only thing. Now, if I take Your Lordship to the affidavit filed by the respondents, they have annexed the UGC regulations 2018. Annexure 1, they have annexed the UGC regulations. And if I take Your Lordship to page 38 of the regulation, of the affidavit,
Affidavit by whom?
by the respondents,
1, 2, 3.
1 to 3. This is,
Mr. Master.
this is
Sir,
by-
just a minute, just a minute. This one inside page 30 something. Page 60. Seems like around 50. No, you are asking for page 30?
38, starts from page 38. The affidavit filed in July 2024 by the respondents 1 to 3.
Respondent number 123 filed something in 30 January 2026, not that one.
Not that one. The original affidavit filed in July 2024. It's quite a thick one.
Yeah. I'll have to have a meeting on this. Can't have pages like this. Well, I'll keep searching everywhere now. Huh? They should be serially paginated like they are done in the principal seat. Okay. 19th of July.
Yes, right.
Yes.
Your Worship, the UGC regulations of 2018 have been annexed by the respondents as Annexure 1. I'll take Your Lordship to the relevant portion, which starts from page 38.
Yeah.
Middle of the page, Your Worship, 6.4. Stages of promotion under the career advancement scheme of incumbent and newly appointed assistant professor / associate professor / professors. So it starts from here, and the relevant portion, Your Worship, is at page 40. This is a career advancement scheme for college teachers.
Yes.
So at page 40, at top of the page, Your Worship, Roman 4, associate professor, academic level 13A to professor academic level 14. Eligibility, number 1, associate professors who have completed 3 years of service in academic level 13A. Number 2, a PhD degree in subject relevant, allied relevant discipline. Number 3, a minimum of 10 research publications in peer-reviewed or UGC-listed journals, out of which 3 research papers shall be published during the assessment period. Number 4, a minimum of 110 research score as per Appendix 2, Table 2. So this is very relevant, Your Worship. Number 4, a minimum of 110 research score as per Appendix 2, Table 2. Then CAS promotion criteria. A teacher shall be promoted if, number 1, the teacher gets satisfactory or good grade in the annual performance assessment reports of at least 2 of the last 3 years of the assessment period, as per Appendix 2, Table 1, and at least 110 research score as per Appendix 2, Table 2. The promotion to the post of professor is recommended by the selection committee constituted in accordance with these regulations. And Your Worship, at page 63
Yes.
is the Appendix 2, Table 2.
Okay.
At page 62, we have Appendix 2, Table 1. This is the assessment criteria. This is for the annual performance, like the ACRs. And Your Worship, Table 2, Appendix 2 is at page 63. This has to be filled in by the incumbent,
Yes.
and accordingly, it is analyzed by the selection committee. So, Your Worship, now, if I take Your Worship to page 40, according to the respondents, the research score of 110, as per Appendix 2, Table 2, has to be obtained during the assessment period. If we read this page 40, Roman 4,
So that will be for how many years?
3 years.
3 years.
Because, Your Worship, if I may read this CAS promotion criteria. At page 40, a teacher shall be promoted if the teacher gets satisfactory or good grade in the annual performance assessment reports of at least 2 of the last 3 years of the assessment period, as per Appendix 2, Table 1, and at least 110 research score as per Appendix 2, Table 2. So, they have interpreted this to mean that even the research score of 110, as per Appendix 2, Table 2, is to be acquired during the assessment period of 3 years. But my interpretation of this, Your Worship, is that the assessment period of 3 years is relevant only for getting satisfactory or good grade in the annual performance assessment reports of at least 2 of the last 3 years of the assessment period. It's a conjunction, and it's a conjunction. There's a gap in between. And at least 110 research score as per Appendix 2, Table 2. So this Appendix 2, Table 2 research score of 110 is not required for the assessment period only, it is required for the entire career period, which according to me is the correct interpretation, because, and we can get a clue regarding this, if Your Lordship will see the eligibility criteria, number 4. As Your Lordship got it, just above that. A minimum of 110 research score as per Appendix 2, Table 2. It does not say during the assessment period. The eligibility criteria does not state at number 4.
So now if your entire career is taken, you have more than 110?
Yes.
And if the last 3 years is taken, you do not have 110?
Yes.
And those persons who were recommended by the this committee,
Selection committee.
the final minutes that you had got us to read.
Yes. At page
Serial number 2 and 3,
have been,
they have the required score
yes.
of more than 110 during the relevant period.
Yes. So now basically it boils down to the interpretation of this eligibility criteria at page 40. Because the only reason the review committee had cancelled the recommendation made in favor of the petitioner, if Your Lordship will see.
Where is that 2018 resolution? At page 36, there are 2 resolutions which they have.
Judge, these 2 resolutions just point to the fact that the UGC regulations will be adopted by the.
Where is that?
Yeah, I'll take Your Lordship to that. If Your Lordship will see the 35th Academic Council at page 49.
Page 70.
Page of the writ petition, sorry, of the writ petition, page 39, 49. The 35th Academic Council minutes held on 26 November 2018 is at page 49. And the 49th Executive Council held on 17 December 2018, the minutes is available at page 51, annexure 19. If I may take your lordship to page 51.
Yes.
Yes, this is the minutes of the 49th Executive Council meeting held on 17 December 2018. At the bottom of the page, Your Worship, the 35th, this is in italics. The 35th Academic Council discussed the above matters at length and resolved to accept assessment criteria and methodology pro forma without deviating from UGC Regulations 2018.
Have you made the UGC a party?
No, Your Worship.
Would they not be the best person to answer it?
Your Worship,
Huh? Why should we interpret something when there is already a body which has framed the rules and which can tell us how it has to be done?
that is one point, Your Worship, but I mean, it's
Because that will be a system which has to be, UGC regulations are there because it has to be followed throughout this country.
the only problem is with regard to this interpretation of promotion
Exactly,
criteria.
it is a rule framed by the UGC, a regulation.
Yes.
Should the UGC not be a party before we interpret it?
If your lordship feels that they are necessary party, but otherwise, your lordship, a plain reading of this, it is so clear that the academic score of 110, it is nowhere mentioned that it has to be sort of achieved during the assessment period.
See, others who have been there along with you and granted the promotion,
Yes.
they have scored it. Yes?
Your lordship, that,
Now, there will be two ways of thinking. One, we'll be trying to make an assessment of what your performance is. This court is not equipped enough with enough materials to see whether it should be for 3 years or it should be for the entire service career. Now, two things were crossing the mind of the court. One, you must perform within the assessment period
yes.
to be considered for the next post.
Yes.
Your earlier performances may or may not matter. But then can we simply say that your entire earlier career is wiped out? We cannot say that also.
According to this, he has to get satisfactory or good grade in the ACR for 2 out of 3 years. That's very understood. Regarding the academic score of 110, nowhere is it been mentioned that it has to be achieved during the assessment period. But the respondents are interpreting it in such a way that this academic score has to be achieved during the assessment period only.
Mr. Malhotra, at least myself, I would not be very comfortable without the opinion of the UGC at least.
I understand that, Your Worship,
Because it is their regulation and by law upheld by the Supreme Court by so many judgments. UGC has the final word. Now here we are talking of a career progression. They have made out a scheme. In the scheme, they are not very clear on it.
yes.
Either they have to clarify it to the court or they have to clarify it to the
Your Worship,
the service
Your Worship
holder
may
at large.
pass necessary orders then. They can be made a party. They can clarify this point.
I would not pass orders bringing them on record. What I can do is I can say that they appear to be a party necessary for the adjudication and therefore you'd be at liberty to implead them.
Your Worship may kindly give a direction to the petitioner. It comes to the same thing. Will you plead them? Your Honor? Will you plead them?
Heard Mr. A. Malhotra, the counsel appearing for the petitioner. Yes, sir, we'll have to ask the UGC to be here.
Yes, my lord.
Because either ways you would not have a problem. If the UGC says it is the entire career, you have to calculate and give him the CS.
Right, madam.
If they say it is the assessment period, thank you, we close this up.
I do agree with your lords. Fully.
Also heard Mr. Swenson and a senior counsel appealing for the, you are assisted by sir?
My lords.
By Ms. Swenson? For the respondent university.
My lord.
Stop, after hearing the matter for some length, this court finds that the UGC and that the University Grants Commission, who had formulated the, what is that process called?
Your Worship, the full form is at page 15 of the affidavit filed by the state. The full form. Otherwise, we can.
The UGC regulations of 2018, under which you'll find it at page 15. I'll flag it with this one.
This notification.
Huh? I've written UGC 2018. You'll find the name here. Huh? I marked it. So and so. On the basis of which the petitioner claims is advancement in career. Full stop. Mr. A.R. Malhotra, letter counsel appealing for the petitioner, has submitted that the the requirement of having a minimum score of a minimum of 110 research score as per appendix 2 table 2 of the regulations was required to be considered on the basis of the research papers submitted during the entire career of the individual concerned, whereas the stand of the respondent university is that the score has to be achieved on the basis of research papers submitted during the assessment period of 3 years prior to his being considered for the in the DPC. Full stop. Mr. A.R. Malhotra, counsel for the petitioner, is accommodated for 3 weeks to take necessary steps to impede the University Grants Commission as a respondent party in the matter. List the matter along with the IA, along with the interlocutory application proposed to be filed by the petition.
Obliged.
Item number 3 to 7.
Your Lordship, I seek your Lordship's indulgence in item number 3 to 7. Although this matter has been fixed for today, I have some personal difficulties. So if your Lordship may fix this matter some other day.
What is the matter about?
I'm appearing for the item number 6.
This matter has been long pending. This matter can be disposed of at this stage. Lordship, item number 3, 4, 5, 6, and 7, they are more or less analogous. The difference is only in the name of, in the contract work. The law is all the same. So if this matter, item number 3 is taken up, Lordship, it may not be necessary for the other parties to, like item number 6, it will be covered by the item number 3.
She is citing some personal difficulty today. What to do on that?
She can leave. My humble submission is that even if she is there, not much difference will be there. Because
All other cases will be taken care of by
You were
this
in item number?
number 3.
Item number 6.
6. And who's appearing in 3? 3, 4, 5, who is appearing?
Samuel,
3 and 4
additional
is the
AG.
additional AG, 5 is Mr. Nunbui, and 7 is Miss Mary.
Oh, you are asking for only 6. What about the rest? Sir wants to proceed with item number 3.
Yes, Your Lordship. For item number 5 also, Your Lordship, if this matter may be fixed for some other date, because Your Lordship, even though they are analogous, but there might be some factual discrepancies.
So we'll segregate these two matters. He wants third to be heard. Item number 3, who appears? Your contract which was given in 2023 is kept on hold.
Yes,
And they want a modification of the terms.
the terms, yes.
And from 23, no work has been done.
No work.
Everything is hanging. Yes, state. Have your instructions on item 3 and 3, 4 and 7. We'll take it up after some time.
Not 3. Okay.
Or you could have at least informed the senior counsel yesterday or something that we will be seeking some time. He comes prepared with the matter, we come prepared with the matter. Then in the court you say 5 matters together gone. Doesn't look very happy. Huh? Yes, get your instructions. Ask the additional AG when he can appear. After some time, sir. Let them have the instructions on a date when they can, or if he can appear today also.
Let's have a fixed date, Your Lordship.
That we can do. When?
Your Lordship, after the vacation on any
14th.
It cannot be tomorrow, huh?
14th.
14th. Okay. Your Learned, heard Mr. Swensulan as senior counsel appearing for the petitioner, who has submitted that that WPC 33 of 2024 can be taken up as the lead case, and the adjudication of the same would also cover the issue raised in item number 4, 5, 6, and 7. Full stop. A request for an accommodation in item number 4 and item number 5 have been made by the learned counsel appearing for the respondents.
5 and 6.
5 and 6, not 4 and 5. 5 and 6 have been made for an accommodation in the matter. Full stop. The learned senior counsel appearing for the petitioner has expressed his objections to the same, since the contracts which were entered into by the agreements which were entered into by the respondents and the petitioners in the year 2023 have been sought to be modified by an office memorandum dated 15/2/2024, and and there has been no progress thereafter. Full stop. This matters again on the 14th of July 2026 for admission hearing. Full stop. The respondents are put to notice that on 14th of July the matter may be taken up for consideration. The matter may be taken up for consideration and final disposal.
No, please.
Item number 9.
Remove this. Get this removed.
My Lord, in this case, the respondent number 8 is yet to file the counter affidavit. But however, I have not received a copy of the counter affidavit.
Respondent number
8 is the additional DC Kamkala.
Yes, who appears for the additional deputy district commissioner?
Miss Lute is appearing.
Ah,
Ms. Luthi,
respondent number
8.
8, who appears?
Your Lordship, I'm appearing on behalf of the Kala Lule. Your Lordship, I have not been given instructions yet, Your Lordship.
He'll come tomorrow with the instructions. Tell him.
Yes, ma'am.
He's coming here tomorrow with the instructions. Tomorrow morning, 10:30, he'll give you the instructions in the court. And then we'll take up the matter for disposal. Have you seen the orders, madam?
Yes, Your Lordship.
23-6, last opportunity to file counter affidavit.
Your Lordship, if I may be given the last opportunity,
Already given. The next opportunity will be with costs. If I have to modify that. Have your instructions. We'll take it up after some time.
yes, Your Lordship.
When is he giving you the instructions, or is he coming here tomorrow morning at 10:30?
Yes, Your Lordship.
Item number 10.
My lord, I've been
Amended
instructed by this honorable court to file amended petition. Accordingly, I have filed yesterday.
Yesterday.
Yesterday. So the same is not yet ready to be put up, my lord.
The learned senior counsel appearing for the appellant has submitted, assisted by Ms. Swensu, has submitted that the amended cost title has been filed in the registry yesterday.
Yes,
Full
please.
stop. The same, however, is not on record. List the matter again on when do you want it?
If possible, tomorrow, my lord. Otherwise, we have a vacation next week. Or after next week, after vacation.
After the vacations, we'll have it.
My lord, on 13th.
List again on the 13th of July along with the amended cost title first.
My lord. Obliged.
Item 11.
My lord, in this matter, I have submitted my interlocutory application for impleading the respondent number 7, the Secretary Land Revenue and Settlement Department, my lord. So,
This is item number?
item 11, my lord.
Yes, where is the IA? Has been disposed.
Not yet, my lord. This is the first time the argument.
I. Okay.
So, my lord, basically, apart from the bona fide oversight of the respondent number 7, my lord, it was felt that in case the matter is proceeded, and I mean, if the proceedings is to continue, and eventually the court may order a re-verification of the land. So, in that case, my lord, the respondent number 7 is a
Yes, any objections?
Oh, Your Lordship.
Union of India, madam, will appear. Will appear. Union of India? Huh? No, you are yet to be, you are appearing for whom? The Union of India?
Objection.
Because since we didn't receive the instruction.
He has filed an interlocutory application where he wants to implead the Union of India. Any CGSC?
No, my lord, the Secretary, Land Revenue and Settlement Department.
No.
The Secretary, my lord.
Whom do you want to implead? Have your interlocutory application. Whom do you want to?
The Secretary, Land Revenue and Settlement Department.
Where do
Government
we
officer.
have that?
It's, my lord, it's in my petition, my lord. The interlocutory application.
No, this is not how an IA is filed. An interlocutory application for impleadment. Is it filed like this?
Usually, my lord, in the
No.
if,
You have to name the petitioners, the petition number, the petitioner, and then you have to name the respondents. Then you have to say that this is the person I want to implead. He has to be there as an opposite party. Once we allow the application, he has to come in as a respondent in the writ petition.
at page 2, my lord, if the application has been stated, my lord, to implead the Secretary, Land Revenue and Settlement Department. as respondent
It
number
doesn't have an address, it has got nothing. How do you file the amended cost title?
My lord, may I think the application, I'll have a look at the application, my lord. If lordship permits, the matter be taken up after some time, my lord. I'll check the records, my lord.
Because, I don't know, here the process may be different, but there are Gauhati High Court notifications. They are not applicable here. They are applicable for all the benches. The formats, is it not? The format is applicable for all the benches. It is, first it is the cost title where you say this is the provision of law under which I am moving the application. It is not there here. Then you say that it is in a matter of WPC number so-and-so where the parties are so-and-so versus so-and-so. Then you say that this is the applicant versus these are the opposite parties. Where the parties sought to be implemented has to be the last person. Then you say this is why I want to implement so-and-so. And then you say that opposite party number 7 may be implemented as respondent number 7 in the writ petition. And then we say, okay, we implement this person with this address as the respondent number 7. Then you file a fresh amended cost title. Because if we allow this in the application as it is now, we will say the Secretary, Land and Revenue Settlement Department, Government of Mizoram. Yes, it does not have any address. It has got nothing. It is another matter that we have standing counsels here, where you give a copy. But if you say steps by registered area or speed post, it will go nowhere. There is no address.
If that's the case, my lord.
Take your time.
Yes,
Perhaps
my lord.
you have a copy of those.
I have several copies, my lord. But my lord, I'll file it afresh. I'll withdraw the application. I'll file it afresh, my lord.
You are for respondent number 2, 3, and 4. Received from Mr. Samuel. We don't know. We have seen a signature here. There's a signature. It's a scribble, but it's a signature. Go through it, find out. You also have your instructions
My
how
lord,
to file
yes.
this implement petition.
My lord, I'm grateful.
After some time.
Item number 12.
Yes.
Also, this matter has been fixed for hearing of the interim prayer. And in the meantime, the respondents have submitted their affidavit in opposition.
They have. When did you file it, madam? Not on record, sir. It is not here on record. The office note says not yet filed. Yes.
Your Lordship, we have filed yesterday.
No, there's no difficulty because the files must have moved
Maybe,
prior
yes,
to your
maybe
filing.
before the file was processed.
It must have
Your
moved.
Lordship, this matter, if my learned senior counsel, respected senior counsel agrees, then we can have, rather than having a hearing on the interim prayer, we can have the hearing on the case immediately after vacation, Your Lordship.
What is the interim you are asking for, sir?
What we have sought for is for suspension of the impugned termination letters. Lordship, the petitioners have been working in
Where
a
is that letter?
capacity.
Where is the
Page-
letter?
Page 32,
Page?
33. Prayer is at page 32, 33.
No, the impugned letter. Where is it?
Impugned letter is
2026.
page 129 and 130. 133.
Have they joined?
Your Lordship,
Yes, this as per 133, page 133, there's an office order by which these two persons were arrayed as respondents number 6 and 7. Yes. Respondents number 6 and 7. They have been appointed on as casual teachers.
Anybody appearing for 6 and 7?
We have served notice, and in spite of that, there's no representation. The principle of law that has been laid down is that a casual cannot be replaced by another casual.
True.
So,
But they say you are not qualified.
they said we're not.
If you're not qualified, then
we're
how
not
can
qualified.
we?
And they are appointing another unqualified person.
Okay. I heard Mr. Swinsul, senior counsel, assisted by Mr. For the petitioners, also heard Ms. Mary L. Kyangtil, and government advocate, for respondent number 1 to 5 and respondent number 8, who has submitted that the response to the writ petition on behalf of, you have filed it for whom, madam?
1 to 5, Your Lordship.
For respondent number 1 to 5 has been filed on 30th of, no, on the 1st of July. On the 1st of July 2026, full stop. However, the same is not found on record. List this matter again on 21st of July 2026, along with the affidavit stated to have been filed on behalf of the respondent number 1 to 5, full stop. The order dated 19/6/2026 records that the notice on the respondent number 6 and 7 had been served on 2/6/2026. However, none appeared for them on the same date, full stop. None had appeared for the said respondent numbers 6 and 7 on 29/6/2026 also, full stop. Today also none appears for the respondent number 6 and 7, full stop. Keeping in view the grievance of the petitioner as raised in the writ petition, full stop, it is provided that in the event the respondent number 6 and 7 have joined in their services consequent to the order dated
12/3/2026,
thus their services shall remain subject to the outcome of this writ petition, full stop. The respondent number 6 and 7 shall be at liberty to file their response prior to the next date of listing.
In the meantime, Lordship will also like to file a reply to the affidavit of the state.
The petitioners would be at liberty to file their response to the affidavit filed on behalf of the respondent number 1 to 5.
And Lordship, the matter may be fixed.
We have fixed it. What is the date we gave?
21st.
21st of July.
All right.
And they're joining, if any, as per order dated 12/3, is subject to outcome of the writ petition.
Item number 13.
If I may please, Your Lordship, in the last court, I was informed to get worksheet regarding the formation of the reasons for unaccepting the so-called notice reply. Lordship, however, I would like to submit that no worksheet is maintained by the executive committee. However, Lordship, I have submitted a detailed explanation by the local administrative officer regarding the reasons why the so-called notice reply was not accepted.
No, this is putting the cart before the horse. You are explaining later on what you intended to do, what was in your mind? Can that be? The
However,
horse has to
Lordship,
stand before the cart.
I have annexed the photos and statements of the from the file itself, and the explanation can explain the reason behind the unacceptance.
Where is the show cause notice?
The show cause notice, my lord.
Hmm?
Show cause notice is at page number 131. Sorry, 132. Uh, 136, Lordship, sorry, 136. The English translation is at 136.
Hmm. Thirty-six is. No, show cause notice says. Where is the complaint?
My lord, at 132.
130?
132, my lord. 132. And 132A is the translation.
Ah. This is very big sentence you have said at page 138. Instead of distributing the money amongst ourselves, we have used it. That is allowed, distributing of money amongst yourselves.
Lord, sorry, my lord, 138.
Hmm. 138A. Last two sentences. A small balance of funds remain. And instead of distributing the money amongst ourselves.
Yes, so they did not distribute
No,
it.
is it even permitted?
No. They cannot do that, my lord. But they have not distributed. We utilized it for the construction of the foundation beneath the reservoir tank. So the tank is the subject matter of that dispute.
This local administrative officer.
Yes, my lord.
This local administrative officer.
Yes.
He has issued this order on the basis of what?
Yes, Lordship, he is part of the executive committee.
So where is that resolution of the executive committee that do this? Please suspend them. We don't want to know the reason. We'll go by your wisdom. saying that yes, there is an inquiry, he needs to be suspended. Very well. There has to be a resolution, a meeting, a resolution or something. It cannot be by a phone call. Come to page 139A. Or come to page 140 rather. Page 140A, second paragraph. Accordingly, in exercise of powers conferred under chapter so and so, the executive committee of the Lai Autonomous District Council hereby places the Sangha village. Is it? So there must be some resolution, some order from the executive council to the local administrative officer saying that please place them under suspension. The executive council will function with how many members? 10, 5, 15?
No, Lordship. About 5.
5.
Yes.
So the suspension has to be at least by 3 of them. 3 persons have to say we want them suspended. It has to be by a majority. If 4 are present, it will be 3. If 3 are present, it will be 2. Someone has to say. Who said? Now, you say the suspension will remain in force until the inquiry commission submits a report. They have to submit a report within 3 months and they can ask for an extension. Yes?
Yes, Lordship. For
Then they
a
can ask for
period of
extension.
1 month.
Then there is no time frame for you to take a decision. You can take a decision after 9 months. All the time the locally elected, the elected bodies, it's an election. It's an election. A body elected by a democratic process is kept under suspension by the executive. Is it permissible?
No, I don't think so, Lordship. However, the suspension is
You
not
may have the best of the
arbitrary.
grounds. You may have the best of the grounds. Writ court, we will not see and look into the grounds. Let this be very clear. If you have a grounds to suspend someone, we are the last court to come and say that no, your ground is not enough. But is there a ground? Is there an order to say that yes, suspend them? Anything prior to 2nd of June 2025 or 4th of June 2025 to show that yes, there was a decision. You have to maintain files, is it not?
Yes, file is maintained, but Lordship.
So, as per direction of whom? This
Note C
suspension
is
he
not
has
maintained.
to.
Note C is not maintained. All decisions are taken verbally.
Verbally? Can it
Yes,
be?
Lordship.
Can it be? Tomorrow any verbal decision can change. Today with all this technology where we are dictating orders in the court, yet we have to sign that order. You cannot keep a recording of this to say that look, the judge says this. Is it? Something has to be there on the records, written down. Yes, how should we file your affidavit? We are not staying your inquiry, but we will keep your suspension in abeyance. This suspension order will be in abeyance.
Yes, Lordship.
Till you file your affidavit in opposition. If you file your affidavit in opposition, the response to the petition, we'll we'll give you the liberty to ask for a modification of the interim order.
Yes, Lordship.
But otherwise, without any records, how can you suspend? And by this instruction, you have already taken a decision that they are guilty. Now, what will the inquiry come up with? He'll challenge the inquiry process also. Everything goes. Then again, you see the show cause notice reply. You had taken statements of the previous secretary and the MDC, executive member in charge, RD, etc. Yes, you never gave it to them during the show cause notice. What will they reply to? Heard, Mr. Counsel appearing for the petitioner also heard, Mr.
Arnold Monsiama.
Appearing for the respondent number
1 to 3.
1, 2, and 3, full stop. By the order dated 29/6/2026, comma, this court had recorded the submission of the learned counsel for the petitioner, learned counsel for the respondent, that an attempt would be made to have his instructions regarding the sequence of events which led to the issuance of the notification dated 2/6/2026, full stop. Today, the learned counsel has placed before this court an instruction issued by the local administrative officer to the learned counsel, giving the reasons of non-acceptance of the reply to the show cause notice by the executive committee. Full stop. It has been submitted that the records, no, the instructions leading, don't say records, that the instructions leading to the issuance of the order dated 2/6/2026 and 4/6/2026 are yet to be supplied to the learned counsel, and on receipt of the instructions, comma, an affidavit in response to the writ petition would be filed at the earliest. Good stuff. Next paragraph. This court notices that by the order dated 2/6/2026, an inquiry commission had been constituted to inquire into the allegations level against the whom, it was against whom?
It was against the village council president and the village
Against
council.
the village council president of Sangau 1.
Sangha 1.
Huh?
Yes, Sangha 1.
Sangau 1.
Yes.
And by the order dated 4th of June 2025, comma, a duly elected body had been kept in suspension, and a caretaker committee was appointed. Stop. The, what is that act? The Lai Autonomous District, within bracket Village Councils, bracket close, Act 2010. Where is that the power for suspension?
My lord, it's at page 100.
Page 100.
Sorry. Yes, page 100.
Empowers the executive committee to order the suspension of the functioning of a village council against which an inquiry is being conducted, which shall be in force until the conclusion of the inquiry by the commission, with immediate effect from the appointment of the inquiry proceeding. Full stop. Section 10 of the Act not section 10. Where is that where they can give an inquiry committee?
10, section 10, subclause 1, my lord. at page 100 only, my lord, on the top.
Section 10 of the Principal Act of the Act empowers the Executive Committee to appoint a commission consisting of not more than 3 persons from amongst the officers of the District Council to inquire into the affairs of the Village Council if it considers reasonable on a complaint in writing that the Village Council is too inefficient or is unable to carry on the village administration, or is acting in a manner prejudicial to the interest of the state, or is known to be indulging in corrupt practices in the matter of village administration. The power and responsibility of the Executive Committee is not Executive Committee, not being doubted in any manner, this court notices that the order dated 26/2026 does not indicate the reasons for appointing the inquiry commission. Save and except state that the Executive Committee did not find the response to the show cause notice to be acceptable. On a specific query to the Learned Counsel appearing for the respondent number 1, 2, and 3 by the court, it has been submitted that the records leading to the issuance of the orders dated 2nd of June 2025 and 4th of June 2025 are yet to be made available to the Learned Counsel for the respondent. Full stop. It is also noticed that the suspension ordered by the notification dated 4th of June 2025 has been directed to remain in force not only till the Inquiry Commission submits its report, but till a final decision is taken thereon. In view of the uncertainty preceding the decision-making process of keeping the uncertainty decision-making process leading to the directions to suspend the Village Council, we deem it appropriate, and this court deems it appropriate to keep the order, to keep the notification dated 4th of June 2025 under suspension till such time that the respondents file their response to the writ petition, full stop, upon which the interim order, now the continuance of this interim order can be reconsidered. Accordingly, the notification dated 4th of June 2025 is kept in abeyance. Full stop. Kept in abeyance, full stop. Kept in abeyance until further orders. Full stop. The respondents would be at liberty to pray for a modification of this order after filing their response to the writ petition. Full stop. It is, however, provided that the village council shall not is kept in abeyance करके इसको full stop रखो. When can you file it? The learned counsel for the respondent submits that the response to the petition can be filed within a period of
After vacation.
2 weeks.
Yes, Lordship.
Within a period of 2 weeks. Stop. List this matter again on the 23rd of July 2026. Full stop. Extra copies be supplied. You have supplied extra copies?
We have supplied, my lord. Steps have to be taken upon the respondents number 4 to 6.
Issue notice to the respondent number 4, 5 and 6, comma, who were the caretaker council through speed post. Full stop. The respondents would be at liberty to file their response to the writ petition prior to the next date of listing.
Obliged, my lord.
Item number 14.
Can you turn on the AC? Suffocating. Huh? Yes?
My lord, this appeal has been filed assailing the order dated 17/4/2026, passed by the civil judge, senior division 2. And my lord, the main contention is that there is a plot of land in one locality in Aizawl, my lord, that is in Dintar. And the western portion of the land has been sold to the present appellant by the respondent number 6 and 7. Both are husband and wife. The husband has expired in 2023. So on the eastern portion of the land, my lord, there was a way which was given and mutually agreed upon during the sale. And in 2010, there was a redemarcation which was illegally obtained by the respondent.
If you are living on that land or if you are possessing that land,
my lord,
when a redemarcation is done, does not come to your notice?
No, my lord. That is the contention.
Let there be no objection or absence of an objection at all. No objection. You forget that part. You are in possession of a piece of land.
Correct.
Someone has come to demarcate it or redemarcate it.
My lord.
There will be some officials involved. Some tape measuring will be there. Something will be there. Some activity on the land.
Correct.
You are not. 2010. You did not object to it.
No, my lord. The signature was obtained through fraud, my lord. That is.
True, but the fact that something was going on your land, you did not see what is happening in your land.
It was only learned in 2024 when an RTI was obtained.
For 14 years, we are not interested in the land. Why now? Okay, we'll issue notice.
Yes, my lord.
And
yes, my lord.
Any interim orders?
Yes, my lord. In the meantime, if lordship would kindly allow the stay of the to restore the order that is 18/7/2025. That prior to the initiation, my lord, the interim stay was granted and it was revoked by the impugned order.
That respondent number 6 to continue her construction.
Yes, my lord.
You want to stay on that part?
My lord.
You want that part to be stayed?
Yes, my lord.
You are the plaintiff therein?
Yes, my lord.
And what happened on 18/5/2026? Where is the order of 18/5/2026?
18/5 my lord.
You want a stay of the order dated 18/4/2026, yes? 17/4/2026.
2026.
What happened on 18? The next date was 18. What happened that day?
My lord, yes, the Vivacon OC was directed to assess the land, and his report is annexed, my lord. His report is annexed at page 171, my lord. And there, my lord, the
page
171. Lordship has it.
Spot verification already done. Continued the construction of the RCC building over the whole disputed area. And what was the order passed on that day?
My lord, the matter was adjourned and simply adjourned on the. I'll have the orders, madam.
And why were they? Why was this order dated 16? The modification done on whose prayer?
No, my lord, the court casually revoked the order, the previous order.
There was no application.
There was no application, my lord. No objections were filed in the CMA, the miscellaneous application. So the next date for hearing is 37. So in that case, my lord,
Just a minute. Why are there two orders?
my lord, one order is for CMA number 759 of 2025, wherein the impugned order has been passed. And subsequently, my lord, CMA number 7485 has been 485 of 2026 has been filed, wherein the contempt proceeding was applied.
Contempt?
I mean, the application states that it's contempt, but the language might not be correct. But my lord, it was stated that an injunction was again applied for in that case. So there are two CMAs in this case, my lord.
So he was allowed to construct on the eastern portion of the building.
Correct.
But she constructed everywhere.
Correct, my lord.
Huh? That is what the
Correct.
report says, no? Heard the learned counsel appearing for the appellant. This appeal is against the order dated 17/4/2026 passed by the learned civil judge within bracket senior division -2 in CMA number 759 of 2025 arising out of civil suit number 106 of 2025. Full stop. By the impugned order, the learned trial court had required a verification to be conducted by the defendant number 1 to 4 and defendant number 5 in respect of their respective jurisdiction, and to submit a report on 18/5/2026 full stop. By the same order, the defendant number 6 was allowed to continue her construction on the eastern portion of the building. Full stop. The learned counsel for the appellant has submitted that pursuant to the aforesaid order, the spot verification had already been carried out and a report was submitted on the 22nd, a report dated 22nd of May 2026 had already been submitted before the learned trial court, and by the orders dated 18/6/2026, just a minute. Has it been placed before the learned trial court, this report?
My lord, the order, my lord, is
It says report is not received.
is not received, my lord. The order has been separately annexed, my lord, since we have obtained through a copy has been obtained.
No, I'm not saying that this report to the civil judge, it is signed on 22/5/2026.
my lord.
Yes, page 171.
Correct, my lord.
And the order of the learned civil judge says that it has not been received on 18/6.
My lord.
Where did you receive it?
The same to the OC. Yes, the OC has been contacted, my lord.
Huh?
The OC has been contacted, my lord, and the same has been obtained from the authority, my lord.
Okay, what did I say? That a report dated 22/5/2026 had been prepared, and a copy of the same has also been obtained by the appellants from the officer in charge of the Vivacown police station, and which is annexed to the appeal at page 171. What is this page 163? It is seen that the directions for carrying out a spot verification by the defendant number 1 to 4 and defendant number 5 has already been carried out, and the same will be taken into consideration, and the same will naturally be taken into consideration by the learned trial court as and when it is placed before the said court, and necessary orders would be passed in the litigation pending before it. Full stop. The learned counsel for the appellant has, however, submitted that allowing the defendant number 6 to continue her construction on any portion of the building, let alone the eastern portion of the building, would cause serious prejudice to the appellant, and as would be evident from the report dated 22/5/2026, the defendant number 6 in the litigation before the learned trial court has continued construction work of the RCC building over the entire disputed area. Full stop. In such circumstances, he has submitted that the order dated 17/4/2026 deserves an interference. Full stop. Next. The matter is pending an adjudication before the learned trial court, and relevant documents have been placed on record before the learned trial court, and appropriate applications have also been filed. Full stop. On when did you file this application? This page 163.
Page 163. It was.
Huh? When did you file it, sir?
My lord, the date of order is 20.
No, we don't want the date of order. We want this application. When did you file it? There is no date, nowhere, nothing. Huh? We want to.
My lord, the application was.
Sir, the application which has been annexed to the appeal, kindly have page 169. Verified and signed on this, no date. Next page, affidavit, no date. There is no filing seal here. There is no date of filing told to this court.
My lord, this is a copy which we.
Tell us the CMA number.
CMA
if you have filed it.
485 of 2026.
What did we say? What is the last sentence we said, madam? An appropriate application, stated to be numbered as CMA number, how much?
485 of 2026.
2026 has also been filed, on which by the order dated 18/6/2026, the learned trial court had recorded that the written objections have been received and the court was adjourned, fixing 37-2026 full stop. In view of the circumstances involved in this FAO, we do not deem it fit to keep the appeal pending before this court, and we also deem it fit that the learned trial court is required to decide to adjudicate the litigation pending before it expeditiously. Full stop. Accordingly, this FAO is disposed of, modifying the order dated 17/4/2026 to the extent that the permission granted to the defendant number 6 to continue her construction on the building in the, what do they call it? Building in the disputed area within LSC number 408 of 1974 is set aside and quashed. Full stop. The defendant number 6 shall not carry on any further construction on the building till 37/2026. Full stop. The learned trial court shall on 37/2026, on an appropriate application being filed by the appellant for restraining the defendant number 6 further on, adjudicate the same application as expeditiously as possible. Full stop. Yes, what more do you want?
That is all, Malo. That is all, Malo.
There is?
That is all. That is, Malo.
I didn't know.
That is all, Malo.
That is all?
No more, no more.
That will do. Stop. The FAO is accordingly disposed of. The learned trial court at liberty shall be at liberty to proceed with the adjudication of the civil suit number 106 of 2025 and other miscellaneous applications arising therein in accordance with law. Full stop. Anything more?
Malo, only one statement, Malo. On 28/7/2025.
On
28/7/2025. Due to the violation of the order dated 18/7/2025, she was imprisoned. And if in case there is a willful violation, legal sanction may be reflected, my lord.
How do we know? We have said that the lower court would decide, the trial court would decide on any application that you file raising these allegations.
Yes, ma'am.
We have given you the liberty to file an application for extension of the stay granted by this court.
My lord, I'm grateful.
We will modify it as required, but intent is till 37, she will not do any further constructions. Whether any permission can be granted after 37, the trial court would take care. Okay?
I'm grateful.
We don't want to interfere in their functioning.
I'm
Yes,
obliged.
next.
Pass over item. Item number 9.
Number?
Your Lordship, I'm appearing on behalf of the respondent number 8, which is Kala Lungle. Your Lordship, as per my, I spoke to the officers concerned. Your Lordship, they have told me that they committed a mistake of sending the PROCEEDINGS comment to the land revenue because they were under the impression that the land revenue and the Kala would have the same affidavit. Hence, there has been a slight confusion, Your Lordship, in that regard.
Who appears for the land revenue? Yes, madam, you are getting instructions not meant for you. Why don't you give it to her?
I have not received such instructions from the It might have been consolidated by the land revenue and submitted to my learned friend, Your Lordship. So that is why I have informed them that there is a necessity for the Kala to have a separate affidavit because they are a separate entity altogether. So, Your Lordship, if I may be allowed to clear this confusion, I will be filing my affidavit in the following in week of after the ensuing vacations, Your Lordship.
My Lord, in that case, if I may be allowed to submit, since the Deputy Commissioner has already submitted the affidavit in opposition, and I'm asking myself whether the affidavit which would be submitted by respondent number 8 would be different from the affidavit.
These were submissions you had to make on the earlier occasion, sir.
Yes,
on the
I-
earlier occasion, you pressed that respondent number 8 must have an affidavit.
No,
This court supported you
Yes,
and
I
said that,
understand.
okay, last opportunity
Yes,
decided.
yes.
Today you are saying what difference will be there?
Yeah, I have said that. I have said that they will only mention that they were only preparing the assessment. Now today they come.
How do you
and
know
say-
what they are going to say?
Because it is writ large in the affidavit submitted by the respondent number 7.
So respondent number 7 doesn't know.
It's from the same office.
Sir, you are making a very dangerous statement. The High Court looks into its own appeal, does it not? In a single
Correct,
bench. Is it not?
Yes.
Then
yes. Now,
office may be same.
the reason I'm
power
saying is
Yes.
that that's the Deputy Commissioner Office. The Kala is also the additional DC, and the additional DC was given the task of preparing the assessment. So here, if you look at the affidavit of the DC, they say that NHIDCL also says that we are not involved in the preparation of assessment.
Your Lordship, if
It is-
I may, now, if if the DC is saying something, the additional DC being Kala will definitely have a separate say, because again, the
He is
authority.
responsible for preparation of the assessment.
Yes, Your Lordship.
And the DC has to approve it.
Yes.
Is it not?
Yes, my
So now if your case is that you need some compensation or whatever, something is to be assessed. Unless the ADC comes before this court and says, I have not assessed it, sir, can we force him?
No.
He has to make a statement before this court that, sir, I'm doing it,
Correct.
I'm not doing it.
Your Lordship is correct. There is no assessment with respect to the second schedule of the 2013 Act.
So let him say why he's not doing it.
Yes, my Lord. Then a date may be fixed.
After 7 minutes, we are back to square one.
No, my Lord, I want to make a submission since Your Lordship is pressing and they are also praying for the time. I want to make a submission, but since Your Lordship is pressing.
Now, what is the submission? Tell us.
My Lord, the submission is that under the Act, 2013 Act, we are the tenant of the land owners whose land has been occupied for the upgradation and strengthening of national highway. Now, as per that second schedule of the 2013 Act, we were also entitled to payment of compensation. So the issue is only that the additional DC has to say that, yes, I have not prepared the assessment. He will only say that. Now, this issue has been brought
Whether
before.
you are tenants there or not, if yes, to what extent is your compensation? Are these things that this court can look into?
No,
sir?
it is provided in the Act itself.
Very good. It is provided in the act that
Act
the
itself.
tenant will be
Now-
entitled.
Yes.
Listen to us.
Yes.
Listen to us.
Yes.
The act says tenant will be entitled.
Yes, my Lord.
Whether you are a tenant or not.
Yes, we are attend.
Whether, how do we know? It's a question of fact.
No, we have submitted. We
You
are
have
tenant.
submitted. You have submitted. There will be so many submissions.
Yes, my Lord.
Can we decide whether you are a tenant or not? We cannot decide.
No, they
It is
have.
a case for? It is a case for?
It is a case for
dispute of facts.
Yes, my Lord.
Therefore, we dismiss the writ petition.
No, they have
Zero.
stated vaguely that we are not a tenant, but in fact
You
we
don't
are a
know.
tenant.
You go and get an order
No,
from the appropriate
we'll have
authority.
to look at the record, my Lord. With due respect, we have to look at the record.
You have to get the record.
No, the record is in this petition. I mean,
Those records are photocopies.
yes, my Lord.
Can we verify the authenticity? No. Dispute has to be settled by whom?
It's
Appropriate
for the
authority?
Now, my Lord, with due respect,
Oh.
here, even though they have proposed that we are not a tenant, but they have not said that in entirety. Since
you are staking a claim that you are a tenant.
Yes, my Lord. we are
Evidence Act says one who asserts a fact has to prove the fact. Will the writ court go into proving facts now?
They have not completely denied that we are a tenant, my Lord.
They need not.
Yes.
You have to prove.
Yes, I have
And
proof.
this is not a court of evidence.
I understand.
You cannot take proof.
let them file their affidavit, the
Yes,
initial decision.
okay. Heard Mr. So-and-so and counsel appearing for the petition. I also heard Ms. So-and-so and counsel appearing for the respondent number 8. Ms. So-and-so appears for the respondent number 5, 6, and 7. And Mr. So-and-so appears for the respondent number 2, 3, and 4. By the order dated 23/6/2026, this court had granted a last opportunity to the respondent number 8 to file the counter affidavit, counter affidavit, full stop. Today, Ms. So-and-so and counsel appearing for the respondent number 8 has submitted that due to an error, the instructions for preparing the affidavit in opposition had been forwarded to the Revenue Department instead of being forwarded to the concerned counsel appearing for the respondent number 8, and therefore the affidavit could not be filed today, full stop. In view of the submissions made and the accommodation sought for by the learned counsel for the respondent number 8 to be allowed to file an affidavit in opposition, this court allows such affidavit to be filed on or before, choose a date, madam.
Your Lordship, before 17th of July.
On or before the 17th of July 2026, with advance copies being served upon the learned counsel for the petitioner and the learned counsel for the other respondents, full stop. List this matter again on the 24th of July 2026, allowing time to the learned counsel for the petitioner and the other respondents to file their response to the affidavit in opposition proposed to be filed on behalf of the respondent number 8, full stop. It is made clear that in the event the affidavit in opposition of the respondent number 8 is not found on record on the next date of listing, this court would consider the personal appearance of the respondent number 8.
Obliged, Your Lordship.
Pass over item again, item 11.
Lordship allows, I will withdraw the application and file it
File a fresh one in the proper format.
Yes, ma'am.
Which we can allow immediately. The learned counsel for the applicant has prayed for a liberty to withdraw the present application in its present form with a liberty. We are praying for a liberty to file afresh. The learned counsel for the opposite parties do not object to such prayer, full stop. Accordingly, IS Civil 131 of 2026 is closed on withdrawal with liberty to the applicant to file appropriate application for seeking implement of necessary facts. I disposed of.
Item number 15.
Yes, sir.
Yes, Your Lordship. This is a petition for a direction to the respondent to duly assess compensation payable to me, Lordship, for compulsory acquisition of my land, Lordship. I am the owner of landed property covered under LIC number 400301 of 2013, located at Sermon Village, Lordship. And then that is within Mamit district of Mizoram, Lordship. And the state government in the Department of Forest Department, Lordship, has extended that contiguous area of Dampa Tiger Reserve within Sermon Village, my lord. And in doing so, my lord,
Your prayer is that the land that has been acquired,
my land has been acquired.
they have
no
the compensation has not been
paid to me.
assessed.
No, my lord.
When was it acquired?
It was acquired, my lord, in 2018.
Yes, madam. You
And
agree that his land has been acquired?
Your Lordship, It has been acquired to the extent that, Your Lordship, initially this whole Sermun village area, Your Lordship, they had requested for the other relocation of their whole village in 2011. And then in 2013, the petitioner owned the plot suddenly in that said area under an LSC. After that, Your Lordship, between 2013 and 2017, the census was taken. The signature campaign of the relocation, as recommended by the 7 villages, was also taken. And then 7 village, it hardly consisted of 900 members, so they were all relocated. Now, Your Lordship, in 2017, there was a publication of extension of the Dampa forest area in the newspaper, that is the local newspaper Wanglaini. It was published in 2017, and even if the petitioner was not aware of this acquisition per se of the land, Your Lordship, him being a civil servant, he should have been aware that his land, whether it was a LSC or not, now his attainment of LSC also is a questionable fact, Your Lordship, because in 2013, how is it that the petitioner suddenly has a certificate in that said area where the extension is to be done on behalf of the 7 villagers? Second is, Your Lordship, now Wanglaini had already published the notification and extension of the said area in 2017 itself, Your Lordship. Now the petitioner did not make a objection to the acquisition at that time as well. And also, Your Lordship, so now a petition has suddenly been filed in 2024. And then, Your Lordship, the additional affidavit filed by the respondent, also there is a joint verification conducted. Even there, Your Lordship, there has not been any kind of development or any kind of plantation or use of that land, the said land which is covered by the LSC. So, and now at this stage, Your Lordship,
Whatever you do with it, with the land is another thing.
Yes, Lordship.
Have you taken the land is the issue, and is he the owner of the land?
He is the owner of the land, Your Lordship, because he has the LSC which is being run by the Land Revenue Department.
Then
But
is
now,
he not entitled to compensation?
But, Your Lordship, but now the area falls under the Forest Conservation Act, Section 2, 1980.
You have acquired that land to make it into a forest land.
Yes, Your Lordship, but at the
When
same...
you acquire it, then you pay him. What you do with it?
At the same time, Your Lordship, he also has an alternate remedy under the Ombudsman to be appointed as per the scheme under which the land was acquired. So he has an alternate remedy, and this has also been applied in a previous case, which is WPC 54 of 2021, where an Ombudsman was appointed, Your Lordship, to
Ombudsman, they say,
Your Lordship, that was a different
because
scenario.
the questions that they have taken up now, that you were not there then, it was published, it was relocated, everything was done.
At that time,
These are questions of fact.
At that time, I was
can we go into
government servant, my lord. I was posted somewhere else.
No, can this court go into that, all those issues?
No.
There will be questions of fact.
Because, Your Lordship,
Which
if I
will
may...
be required to be brought on record by some evidence, which they will keep on disputing.
No, my lord, on that issue, my lord, I relied on Vidya Devi case also. And
no, true. Vidya Devi case is where you can claim
my lord.
compensation once they say that yes, we had to compensate, but this is too late, and there are other owners and this and that and all the things. Vidya Devi, we are not on the delay part of it, or we are not on the of your right to compensation.
Delay is also...
But the proof or the evidence which would be required for us to decide. The moment we say that they should assess it and everything, we have the assessment, if it has to be made. There are questions that it was already the entire village had been relocated.
No, my lord, actually not, my lord.
So that is what the moment you say, sir, actually not, it becomes a disputed question of fact. That is what we are saying.
No, my lord, their document speaks itself. That notification was issued way back in 2018, my lord. And my pass is of 2013, my lord.
But, Your Lordship, if I may interject, my learned senior, 2011 was the year when the request was made by the 7 villagers for the relocation. So now that also becomes a question of fact as to whether he, being a civil servant, he already knew that there was going to be a relocation done. And hence the
Just,
2013.
This is without taking this on record, but
On record, Madam.
do all councils know all the law? Cannot be. Na? He being a civil servant, it may be there, it may not be there. What does he know?
So actually, my lord, that was done well. Only it began in 2017 and 18, my lord. So actually, my past was of 2013, well before that. And
in 2013, you were given that land was settled
it settled
in your favor.
Yes, in my favor, permanently settled.
How you are saying in 2011 it was acquired?
No, Your Lordship, 2011, the initiation for acquiring that said area was already initiated by the Forest Department.
When was it acquired?
It was, Your Lordship, the census and all that was taken in 2013, between the year 2013 to 2017.
Then on this is dated 12th
2018.
of March 2013. Have you seen Annexure 1, page 12 of the writ petition? You settle the land in his favor. Then in 2013, again on the next page, you permit him to keep it under mortgage. On the same day, you also certify the valuation of that land. Page 16 is a big diagram.
Yes, Your Lordship. Your Lordship, if I may at this juncture also admit that there is a possibility that the land revenue might have gone their separate ways. The First Parliament has had their notifications in their own terms, so there might have been a miscommunication on their end. Now rectification is being going on with such kind of issues that are being raised. Now, Your Lordship, if this case is being decided solely on the facts, it will now again unlock another Pandora box, which will entail some other.
Oh, who's filling up the Pandora box? Your government is filling up the Pandora's box. Huh?
So, Your Lordship, now my contention at this stage, Your Lordship, is that sticking solely to his submissions in the writ petition also, as well, Your Lordship. There has been a delay of filing the writ petition, and also, Your
That he
Lordship.
will go by what, Devi? The judgment? If you have used his land, whatever be the delay, delay will not count. We'll take it up for hearing, sir, on the so for hearing in the first week of August, if it is convenient to you.
Actually,
We'll also go through the entire records. Huh?
My lord, actually, in the previous court date, it is stated that it may be taken up today for disposal.
I understand, but
Anyway,
we would not say inconvenience, but
It's up to
we
your
will
lordship.
say that it will be convenient if it is taken up on
My lord.
the 1st of August.
actually, this is an open and shut case, man. It's very simple.
And they might, we also feel that, but we just want to know from their affidavits and all, we wanted to go through to find out.
Actually, my lord, the earlier step that the state government has taken was of 2nd of August 2017, which is page 21 of their first affidavit.
Page?
21 of their affidavit. They have filed two.
How many affidavits?
Two affidavits they have filed. And at page 21
Just
is
a
the
minute, court copy.
public notice. This is the first step taken by the state assembly in the Department of Forest.
One is filed on 7th of August.
7 of August.
And what is the next one?
7.
The next one is on 7/8/2025, Your Lordship.
7 August is 7/8/2025.
No, Your Lordship. The first one is 11 March 2025.
18th March, huh?
Yes, Your Lordship.
So 18th March, which one do you want us to see? Yes, sir? Which one we want us to see?
Page 21 of their affidavit.
11.
Annexure 3. This is the first,
Annexure 3.
yes, the notification issued under section 21 AB of
So
Wildlife
you will have to
Protection Act.
take me through a language which I understand.
There's-
24,
Yeah,
okay.
translation is at page 24. And this is the communication under.
So your land was acquired in
The final notification
2017?
was in 2018. man.
No, 17, this
This
came
is the
in
first
2017.
notification, and the final notification for
2nd of December, this notice of public hearing, you were not present there?
I was not present since
Why?
I was not there in that location, man. Because at that time, well, I have submitted in my affidavit and also in my petition, man, that since I was a government servant, located and posted somewhere else, my lord, completely outside the district of Mam.
You did not inform the landowners?
Your Lordship,
Actually, my lord,
Wanglaini publication newspaper was already there, Your Lordship.
Where is it?
Your Lordship,
Where is it? Where is it? Let us try.
Lordship, it is not in dispute that I was duly issued the revenue pass. And that pass was issued to me. And it is not also dispute that my land was within the acquired land. It is also not in dispute that I was not paid any compensation. The only issue raised by them was that I did not, at the relevant time, raise any question. That is all, man. And that will be taken care by, I think, Vidya Devi and this at a case, man. SD Vora also is.
You were allotted the land in 2013.
13, man.
2017, they acquired the land. And
is
you
the
say that
beginning.
you
The
had
final-
offered your land. You said you had offered your land.
No, I have not offered money.
Oh.
That also, I have also addressed in my counter reply affidavit. One
Where
thing
did
has
I
to be
read?
made clear, my lord. I was also not a part of the villagers who offered their land to the government for the extension of the Dampa Tiger Reserve, my lord. I was not part of them. The villagers living within that village, my lord, who apparently have no revenue pass, my lord. Please kindly mark, my lord. They apparently have no any revenue pass. The villagers living within that Sermon village, my lord. They apparently have no revenue pass at all. They offered it for extension of the Tiger Reserve area to the government, my lord. In lieu, my lord, of they receiving 10 lakh each for relocation fund, my lord. But I was not part of that, my lord. I am not claiming on that footing, my lord. No. My footing, my issue, my case, my lord, is
The law allows you to give relocation costs and do
yes, Your
away
Lordship,
with
that
the
is as
Relocation
per the
Act.
scheme, the relocation scheme which has been of 2007, Your Lordship, the
I was
National
not part of
Rehabilitation and
that,
Resettlement
so,
Scheme,
yes.
2007.
they may also be having an agreement with the villagers, but I am not part of that. I am not the one who is entering into agreement with government. I'm not that man. I have a duly issued revenue pass, the permanent revenue pass, my lord.
If I may, Your Lordship, at this juncture, if the agreement has been signed and also the compensation has been given under the National Rehabilitation and Resettlement Policy 2007, now under what rights, under what claims, or under what act can the petitioner claim a compensation?
Was
That
the
is also-
petitioner part of that agreement?
He was not part of the agreement, yes,
Then-
Your Lordship. But at the same time, Your Lordship, now
Show us that he is not entitled to ask for it.
at the same time, Your Lordship, if I may be allowed to submit that it is not an acquisition per se, it is an agreement. And yes, he has been aggrieved by that agreement. At the same time, again, Your Lordship, there should have been some kind of retaliation or objection on his end at the time of the agreement or the notification
When
when
he
came
is
out.
not a part of the agreement, how can he go and
At the same,
retaliate?
yes, Your Lordship, but Your Lordship, the extension was actually also published in the Wangdaini News on 24/8/2017, Lordship. Even if one Googles it, it is still available online that yes, there was an extension, there was intention of the government to extend that area.
Where is it?
Your Lordship, I have not attached it in
When-
this, but however, Your Lordship, it was there in.
We are not allowed to shut down this live streaming and open Google here. What to do? Hmm? You give him the land in 2013, then in 2017. What is your prayer?
My prayer, Lordship, is for assessment of my land and for payment of compensation as is admissible in law. That's all, my Lord. My prayer portion is.
His land has been acquired, you are not objecting to it.
Yes, Your Lordship.
You are not denying it. His land has been acquired.
Yes, Your Lordship. it has
Yes.
been acquired.
Some compensation.
It falls, the additional affidavit does submit that it falls within the said extension area.
Some compensation has to go. Huh? Short of time.
It's actually admitted, my Lord. Admitted. I think it's open and shut, my Lord.
And you say that you had an agreement with the village council,
Yes, Your Lordship.
or villagers individually.
Sorry, Your Lordship.
Is the agreement with the council, village council, the members, or
No, Your
is it
Lordship,
with the entire
the
individual?
entire individuals, Your Lordship. Whoever
So you
had-
don't have an agreement with him?
No, Your Lordship, because that was again, Your Lordship, the acquisition was only for as per the policy which was applicable at the time of the 2000 rehabilitation policy, Your Lordship. So the ones who were actually affected by the extension, they were given compensation.
Then why do you acquire his land? Give it back to him. If he's not affected, give it back to him.
Your Lordship, it's as
We
per
will
the
see
joint
that
verification.
he has to withdraw the petition. We'll give it back to him.
Your Lordship, as per the joint verification report, it falls within
The core area.
the core area.
So he's affected. Huh?
At the same time, Your Lordship, if at least we may be allowed to verify certain facts through the ombudsman at least. Because, Your Lordship, now this,
So there is no.
there is, Your Lordship, because if I may be allowed,
You already have a joint verification report that it is in the core. What new thing will the ombudsman say?
because now, Your Lordship, Forest Conservation Act also applies. Section 2 comes into play, Your Lordship. And the Wildlife
Everything-
Protection Act also comes into play now.
Day after tomorrow, if this part of the High Court is taken up by the Forest Department that will use it for forest purposes, will it not compensate for that? Some compensation has to come. You are saying no relocation to him, no compensation to him, nothing to him. How can that be? What is he entitled to? Just because he did not raise UN cry in 2017 when there was a paper publication,
Yes, Your Lordship.
when on record he is one of the persons who has got land there, was it not necessary on your part to have informed him that, sir, your land is, we have taken your land? Those paper publications are done for objections, is it not? Calling
Yes,
for
Lordship.
objections in the acquisition, is it not?
Yes, Your Lordship.
So that someone can come and say that, yes, you need not acquire my land. It falls beyond your purpose.
Yes, Your Lordship.
Is it correct?
Yes, Your Lordship.
So his land is in the core area. What kind of an objection can he raise? If it is in the core area, he has got no ground of objection. So he could not have objected. And he is saying whatever is the value of the land as per your law, Give me the money, at least give me the money, I'm not asking the land. Tell us that part. We understand if he had objected at that point of time when there was a paper publication, what could he do? Tell us that.
Your Lordship, at that time, if there was a public newspaper publication, Your Lordship, he could have raised an objection or at least verified about whether the extension is going to affect his land or not.
You say it is in the core. You say it is in the core. He does not object to your taking the land. Please take it. I don't want that land. You take it. I want to give it for forest. Now what is the next step? He did not object to the land being taken. So what is the next step?
Your Lordship,
The compensation.
yes, Your Lordship, or at least challenge notification to the extent that it
He does not need to. How can he challenge the acquisition? We will not allow him to challenge an acquisition. If we allow people to challenge acquisition, you will not be able to do any work. That is the law. Unless one can show that this land is not required, there can be no challenge.
Yes, Your Lordship.
He says that yes, it is required for government work, for public purpose, it is required.
Yes, Your
Please take my land. In the absence of objection, that is what we will infer. Thereafter, he has to get some compensation.
Yes, Your Lordship. Your Lordship, in that regard, if I may be allowed to present a case law which I would like to rely upon.
Please.
Lordship,
Yes.
This is Aflatun versus late Lieutenant Governor of Delhi, 1975 for SCC 285. PAN number 11, Your Lordship. PAN number 11. Your Lordship, if I may be allowed to read from the second paragraph. This talks about, Your Lordship.
Objections were overruled. Declaration can be issued. Plans to state the objections if any to assess.
So,
Yes,
Lordship,
two we have read.
Yes, Your Lordship. So, PAN number 11, it states that to have sat on the fence and allowed the government to complete the acquisition proceedings on the basis that the notification under section so-and-so and the declaration under section 6 were valid, and then to attack the notification on the grounds that which were available to them at the time when the notification was published would be putting a premium on dilatory tactics. Now, Your Lordship, this is on an observation, and Your Lordship, on PAN number 20. Now, Your Lordship, if I may be allowed to present another.
No, you have not completed your presentation on this. Complete this.
Yes, Your Lordship, I will.
Which part you want us to read?
Your Lordship, that is the only observation that I would like to.
That the land had to be acquired?
Yes, Your Lordship.
No doubt about it. He will not get back his land? No doubt about it. He will not challenge the acquisition? No doubt about it. Tell us whether he is entitled to compensation. One simple question. The High Court says, please appoint him. We are not concerned whether there is a post, whether there is a this or whether there is a that. Yes? We say appoint him. Now he has to be appointed. Can anyone come and question why the High Court will pass this order? No. Similarly, government says, I want the land. Take the land. He has not objected. He could have objected saying that this is not a part of the forest area, this is not this is not that. He did not do it. So you get the land. Now he cannot enter the land. That is what Aflatun says. That is what we concede. We agree with you. Now that you have taken his land, where is his, what shall we say, the compensation? The lollipop in return. Sir, don't cry. I have taken your land. Where is that lollipop? Give him that. List again on the. Now I heard Mr. Swain Senior Counsel appearing for, assisted by Miss. Appearing for the petitioners, also heard Miss Swain Counsel. You are appearing for all?
Yes, Your Lordship.
Appearing for all the respondents. Full stop. The matter has been heard at length and full stop. The learned counsel for the appellant, for the petitioner has submitted that it is apparent from records that the land in favor of the petitioner had been, the land had been settled in favor of the petitioner by the certificate of land settlement bearing number 400301/10/90/2013. Full stop. The learned counsel for the petitioner, senior counsel for the petitioner, has also submitted that there is no dispute to the fact that the land in question, which belongs to the petitioner, has also been acquired by the respondent authorities. Full stop. The learned senior counsel has submitted that the petitioner has not questioned the requirement, has not questioned the requirement of the acquisition, but in the writ petition he has only prayed for being adequately compensated in accordance with law in connection with the acquisition of his land. The learned counsel appearing for the respondent has submitted that when the petitioner did not raise any grievance regarding the acquisition of the land, he would not now be in a position to claim compensation for such acquisition. Giving an opportunity to the learned counsel for the respondents to address this court as to the law under which such a proposition can be accepted, list the matter again on the 4th of August. That is when we'll be back. So,
Obliged. Much obliged, Lord.
As a parted matter. At the consent of the counsel, learned counsel for the parties. Yes, next.
Item number 16.
May it please your lordship, this is a bail application filed on behalf of the petitioner Melsom Thara in connection with excise case number 211 of 2025. My lord, this is the second time this matter is taken up. This is the second time this matter is taken up.
Your lordship, in the
This is the second time this matter is being taken up.
Yes.
Yes.
in the last court date, the TCR was called.
Ah.
However, TCR has not reached yet. At the moment, we did not receive any TCR. The case is already charge sheeted.
We'll have to await it. Huh?
Yes.
What are your grounds? Why do you want bail? To carry more NDPS?
Yes, my lord.
No, don't say yes. What is your ground?
My lord, my primary grounds is non-compliance of Section 48 of BNSS.
48 of BNSS.
Yes, my lord. As there is no material to show that the written intimation was actually served upon or received by the relative of the petitioner.
Okay. The TCR called for by the order dated so-and-so is awaited. Ms. So-and-so learned counsel appears for the applicant while the learned additional PP is also present. Full stop. List again on 16th of July 2026. Registry to issue a reminder to call for the scanned copy of the TCR.
Obliged.
Obliged.
Item 17.
Bearing behalf of Mrs. Emily L. Sangte, who will be representing the sole respondent. Lordship, Mrs. Emily is in the process of filing the Vakalatnama and preparing for the written objection to the IA. However, she recently had gave birth to a child. So if your lordship could grant another time to file the wakalatnama and written objection as well.
Lordship, if I make one submission, as per Order 19-3/2026, the learned counsel had already submitted that she had instructions to appear on behalf of the sole respondents. So if last chance may be given, since we've already been evicted from our property.
Already evicted?
Yes, Lordship.
Then what is the hurry?
The hurry is that.
We could have
Lordship-
stopped it if prior to eviction there must be hurry.
No,
After
Lordship,
eviction-
we are not evicted as per the court's order. We are being evicted by the sole respondents themselves. We have filed a stay application. In the stay application, we have stated that, Lordship. So until
You are in the IA.
yes, Lordship, another IA number 198 of 2025.
Which is
have
that?
been filed.
How
So,
many IAs
Lordship,
are there?
there are two IA. 173 is for condonation of 941 days.
Okay, and what is the other IA for?
198 is for stay.
Or
Stay in
without the
operation.
condonation
Yes,
can we stay?
We can. I believe we cannot stay. And also, Lordship, verbally we are being informed by the sole respondent that they will demolish our building.
Go and lodge an FIR.
Yes,
Go and lodge an
Lordship.
FIR that the case is under litigation, they are trying to demolish it.
Yes, Lordship.
Investigation will get you time. By that time we can pass orders. Yes.
Last
Any
chance
notice
may be
issued on
given,
this? No. In IA 198 of 2025, huh? Whom did you? Just a minute. Why did you replace the old cost title?
Pardon, Lordship.
There is some old cost title. What is this old cost title?
Or course, title, the respondent has passed away, so we filed a substitution application.
That was allowed.
Yes, Lordship, that is IA 219 of 2025. Allowed by order dated 28/11.
You write it down on this. The in 198 of 2025, huh?
Yes, Lordship.
You write that by the order dated 6/11/2025. The registry was required to put up a note regarding service of notice upon the sole respondent by tracking posted consignment. Full stop. No office note on the tracking of the consignment is available. Registry to look into the matter and accordingly put up a note. Was notice issued here?
No, Lordship.
Then how this order has come?
In the meantime, we filed the stay application.
No, this IA civil of 198. In this IA appeal, in this IA civil of 198.
Yes, Lordship.
What is your prayer?
My prayer is that the judgment and order dated 29/11/2022 may be stayed. In page number 4, at para number 2, page number 4, we have highlighted that execution case has been filed against us, and on 18/7/2025, the respondent has been herein have forcefully evicted us from our property.
Yes, sir. When are you filing that?
Lordship will be filing immediately after vacation.
We'll fix it on 17th of July. Will it
Yes,
be okay? At the request of the learned counsel appearing for the opposite party, list this matter again on 17th of July 2026. The learned counsel for the appellant and the applicants has submitted that there is a threat of eviction
Yes, sir.
from the disputed property and therefore there is urgency in the matter. Full stop. The learned counsel for the opposite party to take note of the same and ensure filing of the response to the RFA and the interlocutory applications on or before the next date fixed.
Deeply obliged.
Yes. How many more? How many more?
One supplementary. There were also for silence in the parties hearings. That will be necessary.
There's also one mention. Yes. You want to say something?
We read part 2, my lords,
Hmm.
fixed matter. Very short question of law, my lords, pension.
At 2.
My lords, part 2, item 5. At 2, my lords.
At 2.
Yes, yes.
Part 2 at 2. Nothing.
prepare compilation of judgment.
But what one thing we are not understanding, Mr. Counsel, you on the yesterday you said that matter was substantially heard.
At length.
I do not remember hearing this matter substantially on any day. Huh?
No, actually, yesterday it was before court number 2, and it was supposed to have after DB, but the councils all of a sudden, and they call us, they phone us, then the council for the respondents were not there. So then, since this matter was before you, before making that the cost list, because court number 1 took up that item, this one, writ petition, so it was before you, but since because of that consumer matters, at last minute, they shifted to court number 2. Then it came before you.
I don't know.
And my lordship, you make a fixed timeline also for submission of all the pleading, and you pass the order not to publish any documents, any statement in social media, any personal that matters. That is regarding
that was the interim order we had passed.
Yes, yes.
And that was on the first day because
yes,
we felt that yes, they should be restrained from all that.
Yes.
Now eviction notice, they are saying there is no eviction notice.
It seems
to
the court directed, we had hearing, and Justice Michael, so then they withdrew that. After that, they file affidavit also.
So now your prayer A is granted.
My prayer is granted, but that affidavit, I have not seen any kind of, I said, in that.
Sir, we talk of a relief which can be given, or we talk of prolonging the litigation, dragging it on.
Yes, main as of now, our main is that even bank account also defreeze also. Main case is that for setting aside of the impugned PR. That is the genesis or the PR, wherein we are described as the main culprit because of the PR.
Show us the PR.
It's the PR is at page number 28.
20?
28 of my writ petition.
Press release.
Yes.
Yes. Where is your name?
May I kindly furnish my submission?
Where is your name?
My lord, it start the English translation is 31.
Oh, just tell us where is your name.
My lord, it at the last, the conclusion part.
Read it.
Based on the lines of investigation, R.L. Pekka, 62 years, son of late R.L. Dama, residents of Tansil Venglui, was identified as principal accused and responsible person in the murder of Marina. In this investigation, Tansil YMA FSL team provided significant assistance to the police for this cooperation. The SP, along with its staff, expressed their appreciation and gratitude.
What is wrong with this?
My lord, that's why, first of all, my submission is that there is a judgment, long line of judgment by PUC Supreme Court, wherein the guideline to be followed in issuance of police PR. Because that issue came because of, it's happened many times that police encounter case, it's happened many times. Then
Show us the judgment.
I think I have given.
Which judgment?
Then two issues were.
First let us conclude this issue. Tell us where that guideline is there for PR.
My lord, 38, it starts from 38, from the judgment.
He is the person who was accused, who is no longer in this world.
Yeah,
where is the question of a trial?
Yes.
Where is the question of a trial?
My lord, there is no trial, but by that their impugned PR, because of the impugned PR, they burnt our village, their house, everything, and eviction was the issue.
That is the second part. You are saying that the press release has to go.
Yes.
Tell us, now the present petitioner or his family is not named in the
My lord,
press release anywhere. They say so and so has expired and he is one of the main accused, he was one of the main accused. Thank you, public, for helping us. Now what happens?
My lord, the thing is that it is well settled that even they, the family members, even they suffered because of this publication.
That is one of the repercussion.
Yes.
That is one of the repercussion. We are, if we now set aside the press release,
Yes.
how is it going to affect you?
My lord, if it is set aside, because even that, after that, my lord, allow me to read this, that small paragraph. After this, Supreme Court, the Amicus submitted this guidelines, Police Manual 54.
Yes, who appears for the Union of
And
India?
54
Is that now there will be two things. Either we can ask the Union of India what are the guidelines,
Yes.
whether guidelines had been followed or not.
Yes.
Yes?
It has not been followed, my lord.
It has not been followed.
Because it
So-
should be for a forensic report, details report should be withheld. Here it's very written very clearly, 8.3, clause number 3. What are to be
Page
withheld?
number?
It starts from 55.
You are showing us 23.
Evidence, theory, confession, witness accounts, forensic details.
Yes, who appears for the police? Yes, madam, tell us. Why all these details were divulged?
Your Lordship, this is the normal procedure which is usually,
Your normal procedure will be beyond the Supreme Court.
no, Your Lordship, if,
Can your normal procedure be beyond what is required by the Supreme Court?
no, Your Lordship.
No. Supreme Court says you will withhold evidence theories. You will withhold confessions. You will withhold witness accounts. You will withhold forensic details. You will withhold call detail record. And you will also avoid investigative tactics. Now, if we read your police or your press release,
Yes, Your Lordship.
please come to this part, page 31.
Yes, Your Lordship.
Witness, third one, two, three, fourth paragraph. During inquiry, do you find the paragraph?
Yes, Your Lordship.
It was revealed that Marina was pregnant, though the identity of the father was not known. Witnesses stated that Marina has mentioned her intention to marry and the prospective groom was an elderly pensioner. It is also learned that the prospective husband is not a permanent resident. Then, please come to page 32. Top line. Second paragraph. Further analysis of Marina's mobile number, CDR, call detail record. During investigation, now come to the next paragraph. Cervical vertebrae and 8 tooth suspected to belong to so-and-so recovered were sent for FSL. Based on witness statement and forensic evidence, it was established that. Why did he override the Supreme Court orders? This is contempt. This is contempt, madam. Is it? On 23/1/26, forensic examination reports were received. Reports confirmed. What all are you placing? And you say this is normal and standard procedure. What is the respondent number?
My lord, respondent number 5. 4 is the one who issued this PR.
No, no. This has been issued by the IG.
Yes.
Respondent number 3, Lordship.
How could he do it?
Your Lordship, if I may be allowed to read out the affidavit of position wherein...
Of respondent number?
Your Lordship, for the state respondents, Lordship, 1 to 4.
No, I want an affidavit from number 3. Secretary will direct the respondent number 2 to start a disciplinary proceeding against this man. One and 2 will hold a disciplinary proceeding, give us a report. Does he have no idea? He has given a press release.
Yes,
Based on that, the entire community went to their house.
Yes, sir.
We will accept 5, 6, and 7, or whatever those persons who had made those WhatsApp messages. We will accept their truth. They wanted to stop it, say, for the time being. That means the IG has instigated the whole thing. Property was burnt.
Yes, Your Lordship.
Scooters were carried away and burnt.
Yes, Your Lordship.
Then he has instigated the whole thing by overriding the PUC judgment. Either he seeks an apology, withdraws the PR, says that it was wrongly issued, it was erroneously issued, and nothing in it shall be deemed to be an information to the public, and we apologize for the same, or the person who signed it, he faces an inquiry.
My lord, copies were given to the media people for wide circulation.
Sir, don't add fuel to the fire. It is
All right,
already
Lord.
burning. Don't add fuel to the fire now.
I apologize, Your Lordship.
Your Lordship, I would leave it to the...
Court.
Yes, Your
We
Lordship.
will be in
at
a
this
very
stage.
deep soup. Don't leave it to us. Have your instructions.
Yes,
Whether they propose to withdraw that press release.
That, Your Lordship, I have inquired.
They would not.
No, Your Lordship, because that will actually question their authenticity as in the investigation
what?
itself.
Huh?
Of the findings and the ongoing investigation, Your Lordship, which will hamper the proceedings in the district court as well.
If they withdraw this press release, who is stopping the investigation?
Your Lordship, it might adversely...
How? When they were not required to release certain details.
Yes, Your Lordship.
They may say that we have done an investigation. It points towards so and so person
Yes, Your Lordship.
as an accused, and the investigating is going on very fairly, and since the person has died, we are trying to explore if anybody else was involved. Simple press release
Yes, Your Lordship.
that we have identified one accused. Unfortunately, he is dead. Matter over. Why are they trying to prove to the public that, look, sir, we are very good? Huh?
I bow before this court, Your Lordship. I do not have any submissions further than what has been submitted in my affidavit.
What does your affidavit say? Your affidavit says this is part of the investigation which is
Yes,
correct,
Your
and we have got records to prove
That-
that this is the correct investigation. Yes, we have read your affidavit.
Yes, Your Lordship.
That is what who has signed it? I have not seen that. Who has signed it?
Your Lordship, the Under Secretary, Home Department has signed it.
Huh. Now this Under Secretary of the Home Department will be now in trouble. Does he not know about the Supreme Court ruling? It cannot be taken as a matter of ego. We are not taking it as a matter of ego. We are not taking it as a matter of ego for him, even for the state. There is no ego problem here. The problem is, what does the Supreme Court need you to divulge in a press release, and what should you not divulge? POCSO matters are very grave matters. Why do we switch off this thing? We switch it off. We sometimes uphold the conviction, we sometimes acquit him. We don't want everybody to see what are the allegations and what is the proof and what was the language used. And that is why the Supreme Court says that it will hamper your investigation if you tell everybody everything. Now he has come up with a pig story. I was carrying 60 kilos of pig and 70 kilos of pig in the vehicle. If you had not told him this part, he would not have come up with a pig story. You are hampering your own investigation. Okay, that is one part of it. What is your next prayer?
My lord, in this respect, one more thing is that Putta Shomi 9 judges bench also, right to privacy is the fundamental right also. I have enclosed the judgment.
Let us also be reasonable on this.
Yes.
This press release has implicated your husband.
Yes.
And this press release does not say that there are more people involved in it. We suspect that there will be another 2-3 people or whatever. It was
Yes.
done by the WhatsApp messages.
Yes.
So this press release is not against your right to privacy.
My lord,
Whatever
it's
was
affect-
there against your husband
Yes.
was brought on record by the press release.
Because of the press release, they burnt our house. We are evicted.
Now that is how one understands the press release.
Yes.
How the public understood it.
Yes.
Now we cannot hold the entire public at large to be guilty of misunderstanding or understanding. Yes. So now let us come to page 23 for a moment.
Yes.
Come to page 23. And yes, you have to also tell us. The last order asks you for a report. Where is that report?
Your Lordship, I have not received.
Madam?
I have not received it, Your Lordship.
You have?
No, Your Lordship, I have not received it.
You have not received it?
No, Your Lordship.
Yes.
My lord, my
Prayer,
very second prayer
page
is that
23.
for compensation.
Just a minute. Page 23, prayer A.
Yes.
Impugned eviction notice. You had asked for a quashing.
Yeah, this is the one.
They have said it was no. We are sorry.
Yes.
We are not evicting anybody. Yes.
Yes, my lord.
Your first prayer is answered.
It's answered, but actually, my lord, what is happening in Mizoram?
We will
And
come
also,
to
I
that.
have, my lord, allow
We
me.
will come to that later on.
Yes.
Let us go step by step.
Yes, yes.
Your eviction is now no longer an issue.
Yes. Secondly, the one we just have stated, the police PR.
Sir, I have a cycle and you are moving in a car.
Yes.
I am not being able to catch up. You have to go at my speed.
Yes.
Okay. So A is answered. Now what is B?
B is that we just have stated that the police
statement.
PR.
That we will do what we have to do right now.
Yes.
C
this is very important.
that is a report that we had called for. She does not have the report as of now. So
And
we'll
also,
see
my
what
lord,
to do.
in view of the, I'll come later on also, because they have to be arrested, they have to trial, special court have to take it up, this matter.
Yes.
And
Then we have
D is already allowed.
Allowed. Your
Yes.
account is now working. Yes.
And E.
And E will come after we decide B and C.
Yes. My lord, actually E, I don't know, today also they will be admitted because they cited this judgment, true judgment on 9/6, just before Justice Michael. They cited suo motu destruction of property by Supreme Court. Then they admitted that and will compensate, will pay compensation. So that issue, I think we can close it, this matter also. Is
Now you have admitted because of the compensation, anything? He's saying you are admitting it?
Your Lordship, at the previous hearing, it was stated that a query commission can be set up. That was
Have you done it?
Not at this stage, Your Lordship.
So who would be the right officer to answer us?
Your Lordship, the district magistrate would be.
The IG issues the press release, number one. Then the police is investigating the suo motu FIR. You are saying a zero FIR. What is it?
Yes,
What do you call it?
Zero FIR.
Zero FIR. You are investigating the zero. What can the DM do? What can the district magistrate do?
Lordship, for the to come to a definitive quantity and for the amount that is quoted.
That is separate. Prayer B and C. The press release part, he is the SHO. Who should come? To explain as to why the what they want to do about this Supreme Court contempt. Direct violation of the orders of the Supreme Court.
Your Lordship, if I may be allowed to gather instructions as to whether the press release can be set aside.
We have set aside. Why do you need instructions?
And then they can have a separate inquiry.
That is our prerogative. We will set it aside. But we wanted the authorities who had made a mistake
Yes, Your Lordship.
to correct it. Because once we correct it, then other things will follow.
Yes, Your Lordship.
We will be bound to do other things. We don't want that to come on the state.
Yes, Your Lordship.
Because we are still trying a presumption of innocence to say that it was done on a mistake,
Yes, Your Lordship.
not deliberate. Contempt will be deliberate.
Yes, Your Lordship.
We don't want it to be deliberate. And this officer in charge of the that zero FIR, who is investigating it?
Your Lordship.
Where did you say about the zero FIR?
The IO is the officer in charge in Vaivakon police station, Your Lordship. That is respondent number 4.
So what we will do is, we will fix it on the 4th of August.
Yes, Your Lordship.
On the 4th of August,
Yes, Your Lordship.
you would tell this court regarding the steps. You give them this judgment.
Yes, Your Lordship.
Do they know about the judgment? As of now, possibly not.
Yes, Your Lordship.
They are happy to think.
And
that
the Undersecretary, Lordship, on his behalf, I would like to plead that he's an administrative body, so he might not be aware of the judgment, Your Lordship.
My Lord, may I please, because actually this matter, we tried to dispose of on two occasions. So due to unavailability or personal problem of the government advocate, we could not, if you see the other 2 occasions, I've come all the way from Delhi for this matter. Even Friday also came down because this matter attempt was made to dispose of the matters.
Okay.
Because now we feel that this is a simple issue. Before also, because now, only one prayer that it's directing this for making a case, registration of a case is open and
That has
such
been
case
done.
by the judgment. Tasin Lal is there. I'll read it.
The FIR has been registered.
It was registered, my lord. If I may allow to cite the judgment, because it is Tasin Lal.
If they have registered the FIR, thereafter can we say that now you close the FIR, you finish your investigation within 3 days? Can
My
we say
lord,
that?
actually, the judgment of the Supreme Court was completely ignored by the way how they conducted this trial, how they took up this Shwamoto FIR, which happened on 29 also. That's why, my
Where
lord,
is that?
allow me to 57 in lordship, or my compilation, 57.
Yes.
This is the case where cow slaughter, there is an issue. It came up till Maharashtra. So then there was a mob violence against that. And that is very landmark judgment. They also submitted 2 judgment. It is also good for me also. I rely upon their 2 judgment also. But 19 para 19 is very relevant. Page number 79.
No, all this has been done. Tell us what.
And also they have to be arrested,
Where?
that again from 40, 89.
Huh?
89. It starts from 89, 40.10. Allow me to read, Lordship. 89.
Wow.
It shall be, may I kindly read? It shall be the duty of the central government as well as the state government to take steps to curb and stop disseminations of irresponsible, explosive messages, video, and other materials on various social media platforms, which have a tendency to incite mob violence and lynching of any kind. Because they are the one who issued this. And 40.11, the police shall cause to register FIR under section 153A, IPC, or any other provisions of the law against the person who disseminate irresponsible and explosive messages and video having content which is likely to incite mob violence and lynching of any kind. 40.12, the central government shall also issue appropriate direction, advisories to the central government. And again, there is a remedial measure. Despite the preventive measures taken by the state police, if it comes to the notice of the local police that an incident of lynching or the mob violence has taken place, jurisdictional police station has immediate cause to lodge an FIR without any delay or under relevant provisions of IPC such and such. And my lord, 40.15, investigation in such offences shall be personally monitored by the nodal officer who
Yes.
shall be duty bound to ensure that investigation is carried out effectively. Charge sheet in such cases is filed within statutory period from the date of registration and arrest of the accused as the case may be. My lord, here the way how the government initiated took up,
So
if we
now-
don't come to the court, they'll not do anything.
No, now you want a disposal today, yes?
Yes, my lord.
What is the possible prayer that you have?
My lord, here to direct
What
and
should we direct?
to in respect of that the PR. So in all respect, I think even Putushomi judgment, you are aware that 9 judges bench also, right through privacy is a fundamental right. And on that basis, on PUC judgment, it must go in all respect. And the part 1. And because it
will set it aside, we'll caution them.
And second is that very simple one, just direct the police to register, they already register, arrest or file FIR as prescribed by the court.
Whether to arrest or not.
Well, that's up to, you cannot, the court cannot decide it. But if, just to take as per, because as per the law,
we can give one sentence that since an FIR has been lodged, now it will proceed in accordance with law. Are you happy
definitely,
with-
that is also
you
fine.
are happy with
That's
that?
fine. Because
And-
if they have not done, we can come again for contempt also. And that the third part, I don't know, my lord, actually interestingly, that regarding 7,61,310 rupees part, the government did not say anything in that counterpart. They just simply admitted that. That I have stated in my para 26, and the reply to 26 is needs no comment. And they submitted true judgment. My lord, that true judgment, in fact, it is good for my case also. It really supported my case. In case of mob violence, half of the compensation is also to be paid in their judgment.
By the state?
Yeah, by the state.
But for that, Your Lordship, again, as suggested, query commissioner has to be appointed. That was the
Have
only
we
reason.
appointed?
That was the only reason why we had
But
produced
my
those
lord, in
judgments.
this
Your Lordship.
case,
appointed.
in this case, they admitted. In that case, it was not admitted. It was not known in that case. But in this case, and they categorically admitted, they did not deny anything. That's why 7,61,000. In fact, my building, 6 stories building, it was burned. I don't know whether we can come up by it or not. Because for purchasing, it will be around 60 or 50 lakhs. So far, how much we have paid, that we have not calculated. Only we calculated that part, they burnt only. The scooty, in the presence of the police, if you see the photographs.
So now with respect to the prayer number 1, let us now, okay, we are closing it today. With respect to prayer number 1, they have withdrawn that eviction notice. They have made a statement. It is not
Yes,
an
my
eviction
lord,
notice.
allow me
We are
just.
districts.
Yes. Actually, my lord, this is such an important case in Mizoram because in Mizoram, what is happening is recently 3 incidents happened, I think in this year. One who was accused of under NDNPS. His house was vandalized, burnt, their vehicles, happened. It became viral recently in Dinthar. So he got bail also now by the court also. They did not come to the court because they are afraid of the NGO, the public like this. And eviction notice was issued. And again, the leader in Amveng, and he was a leader in local authority also. Again, same thing happened also. My lord, also, I have cited 5 judgments. Even my pleading also, I have made table also. Wherein just selling liquor, NGO evicted. And just marrying a non-tribal, they evicted. I have the tabular form, I have made it also, the judgment also, I all included. My lord,
That would perhaps be an issue for some other sort of litigation.
My lord, that's why
Here I can concentrate on your prayers.
It's fine.
You are asking for a disposal. I am trying to find out what is your requirement.
Yes.
Prayer A, the eviction notice goes.
My lord,
They have
actually,
admitted it's a wrong notice. We did not intend to evict. We never had the intention of evicting. And whatever remedial measures we will think of,
yes,
we will see.
because my lord, if you see their affidavit, withdrawal affidavit, I did not find any kind of withdrawal, but what I submitted, they presume, they think, their submission is that we issue eviction notice because to appease the people, the public outrage, because they did not have authority to evict anyone at all.
So now we set it aside by saying
Yes.
that they did not have the authority,
Yes.
and what they have done possibly was not in accordance with
Yes,
law.
that is what
Yes.
exactly. Because they
Now-
did not have power at all.
For D, your prayer is already answered,
Yes.
your account is defreezed.
Yes.
Then you have B and C.
Yes.
C, we cannot say. Registering of the case has been done. Arrest of the culprits will come in accordance with law. If
Yes.
they need to be arrested, they'll be arrested. If they
Yes.
need to file a charge sheet, they'll file a charge sheet.
But that's,
And
if
the
you
complaints-
allow me to just to cite that Tashin judgment, in view of the Tashin judgment, if they go according to the Tashin judgment, because Tashin judgment direction was given to the state government also.
You are not asking for those reliefs. You are not asking the question whether the central government has a scheme and the state government has a scheme or not. Where is that question?
My lord, my submission is that registration of the case, we did not know initially. After filing only, we came to know.
So once the case is registered,
Yes.
your prayer C is answered.
Yes.
You don't have anything to say on
But
prayer C.
to take the law as its own course, that is what I want to know.
That they will necessarily do.
Yes.
And that is why that is why on the last occasion,
Yes.
this court had asked them to bring a report on the stage of investigation.
Yes.
We were trying to help you. You want a closure.
Yes.
So we'll now close it, leaving it to its fate.
Fine, that is all right, my lord.
Then, so far as B is concerned, the press statement we will quash because of the judgments of the Supreme Court.
And also, my lord,
And
petition
for
of the judgment.
violation, we will leave it upon the appropriate authorities to initiate such proceedings as we deem fit.
Yes, Your Lordship.
Yes.
And so all your prayers are answered.
And compensation?
And the compensation, since it is an admitted position, Supreme Court says 50%. State will give 50% of whatever you have admitted. And whatever is not, whatever
Your Lordship,
remains,
based on the query.
you will find out the culprits and you will recover from them and give it to him.
Yes, Your Lordship.
And all this will be done within a period of, tell us now.
Yes.
Tell us your time period. 6 months?
6 months is sufficient, Your Lordship.
You are saying something, sir. You are appearing for
Respondent number 5 to 8.
5 to 8. What do you say? You want to evict?
Signed by the reviewing ethics.
So, you have given a notice, or what did you give? You have given an affidavit saying you have given this and that. What have you given?
That the impugned eviction statement was not furnished to the family of the petitioners. It was just posted to WhatsApp group. And we have already filed.
No. Your page 7 of your affidavit. Please come to page 7 of your affidavit. That is what? This is what? This, where have you given? Withdrawal notice? Your affidavit dated 11th of June 2026. Have you seen that? Yes. Do you have it, page 7 and 8? 7 is the vernacular and 8 is the English translation.
Lordship.
This you have given only in the affidavit. Where have you published it?
Lordship, there is a bona fide mistake in translation error.
What is
That,
the mistake?
we has in the original vernacular statement, we have clearly expressed that we have withdrawn the eviction statement dated 2701.
We have?
Expressly, we have withdrawn the eviction statement.
Understood,
But
understood.
it was not published.
Understood. Where have you published it? You gave everyone on their WhatsApp message. Now, this
That the
withdrawal
last
where have you
order,
given?
that the last order, any not to publish. That's why
so-
we.
Oh, that's
That's why
So
we.
now,
I asked him, he said that one is your order because not to publish anything.
because we wanted you protected.
Yeah, that's what.
So now, where will you publish it? In papers or WhatsApp groups or Instagrams?
My lord, Banglain is the leading newspaper in Mizoram.
Huh?
Banglain is the leading newspaper.
My lord, that the earlier eviction statement was also posted at our WhatsApp community group in our locality. So we have to post again. So if the court deemed
But it came in
necessary-
public all over Mizoram.
No, you publish it in a newspaper. In any newspaper you say.
My lord, Banglaini is the most leading. Banglain is the most leading newspaper.
We'll say that you will have it. You will have this published in a local daily newspaper regarding the withdrawal of the notice. Huh? Okay. Then what do you want? Tell us.
That's it.
What
That's it,
more?
Lordship. I'm very much obliged.
Your Lordship, if I may request, Your Lordship, in the previous hearing itself, I had submitted a judgment which is in redestruction of public and private properties, 2009. So, Your Lordship, if I may be given, if that also may be quoted in the judgment itself.
Which part?
Your Lordship, that is
Which part? you
parent
want
number
to-
15. Parent number 15, which talks about claims commissioner, Your Lordship.
Huh?
Parent number 15 of the judgment speaks about claims commissioner, appointing a claims commissioner, Your Lordship, to assess the damage.
It is when the damage is not known.
Yes, Your Lordship.
You have admitted the damage in your affidavit.
At the same time, Your Lordship, it has not been quantified. We are at least.
You said no. We are not required to give comments. Finished. Doctrine of non-traverse. You did not answer. Why should we give you that liberty? But then we'll have to appoint some retired high court or a district judge as a claims commissioner.
Yes, Your Lordship, if that is a possibility, to accurately assess, Your Lordship, the damages, so that, Your Lordship, because it has to be given by some competent authority, the amount, to verify, Your Lordship, because at this stage, Your Lordship, the court is not a civil auditor that can say, okay, this is how much you want, so you'll be given.
No, we'll say the admitted amount. Why should we assess? You
Lordship-
did not challenge it. Yes, then suggest us who is the commissioner.
Usually, Your Lordship, it is either it's a retired judge or the district magistrate.
Sitting or retired district judge.
My lord, 7 lakhs is not such a big amount for the government because since they had not denied at all, even my lord, presuming but not admitting, see 5 stories building, and you might see the pictures also. I have enclosed also we lost the building also, even though they withdraw.
But then the assessment report has to come to the court and then we will have to see whether it is correct or not. This destruction of public properties versus state of EP. the claim commissioner will make a report to the High Court or the Supreme Court, which will determine the liability after hearing the parties.
My lord, actually, this is under
Your
another
Lordship,
laws.
we
Because
can
it
be-
comes under destruction of property, because this is a mob violence, it has not come under that law.
But then, Your Lordship, if the learned counsel's main concern is about the time it will take for investigation for assessing the damage, we can be given a timeline, Your Lordship.
No, even after you make that assessment,
Yes, Your Lordship.
it is still to come back to the High Court.
So, Your Lordship.
Have you seen that paragraph 15 last?
Yes, Your Lordship.
Roman 10.
Point number 10. Yes, Your Lordship.
A report has to come. These are guidelines.
Yes, Your Lordship.
But in your case, you have not denied that 7 lakhs something. I don't think there is going to be any commission. We'll quote this, we'll quote your submission on this. But once he made a particular claim that this is the amount, and your affidavit says no comments, we take it to be accepted. Anything else?
No, Your Lordship.
Heard Mr. Swensu, learned counsel paying for the petitioner. Also heard Ms. Swensu, learned counsel paying for the respondent number 1, 2, and 3.
1, 2, 3, and 4, Your Lordship.
1, 2, 3, and 4. 7. Mr. Swensu, 4, 5, 6, 7, 8. Hearing concluded. Judgment reserved.
My lord, can I furnish that? I have only that chapter 8. This is the full police manual.
Of?
That police manual. Because of the PUC judgment, that is the complete one.
And in case you want to submit your written submissions or something, do it by tomorrow.
Yes, Lordship.
Do it by tomorrow so that I do not forget what you have argued.
Yes, Lordship.
Part 2, item number 5.
My lords.
This entire file, you will make PDF. Tell the registry to make a PDF. All the judgments, everything. Along with the police manual also. We'll make a PDF and then give it to me. Yes.
My lords. My lords, here the only issue is, my lords, we are claiming only one thing. My lords, we are the legal heirs, and my lords, petitioner number 2 is the mother of the officer who was employed in the department. My lords, today we are only claiming the release of the pension and other retirement benefits, my lords.
Okay.
My lords, why these monies were withheld until now? He had passed away in 2016. There was a major punishment imposed on him in 2013, my lords. Just a factual background, my lords. My lords, in the major punishment, because, my lords, I was found to have caused pecuniary loss to the government, certain amount had to be recovered. The orders said to recover it from my salary, which they were. I died, my lords, 3 years thereafter in 2016. Thereafter, my lords, the legal heirs, we have come. We have been claiming before the department through representations. Up until now, my lords, until the filing also, my lords, after, nothing has been released. Now, my lords, if the department or the government were to withhold any amount, I am saying, my lords, they can do it as per law. But, my lords, they cannot just arbitrarily say that since there is an amount to be recovered, therefore we are not withholding whatever amount that was due to the officer.
Okay.
So, my lords, this fact is not disputed. Ultimately, the question is Can the government now, after my lord's passage?
Are you entitled to family pension or something?
Yes, yes. Very short question.
So what has been withheld?
My lords, if your lordship sees our prayer portion at page 23 onwards, my lords, we seeking the gratuity.
See, gratuity would be when there is no punishment.
Yes.
You were in service when you expired.
Yes, yes.
Your husband was in service when
Yes.
he expired. What was the total amount required to be recovered?
My lords, at the time it was 43 lakhs. I was a storekeeper in the Food and Civil Supplies Department.
But the employee did not challenge the...
Unfortunately not.
So 43 lakhs was required to be recovered in... And
From the salary.
in what mode? Where is that order?
Your lordships, page 117, my lords, is the original. We've made a two-type copy at 119. 119.
117 and 18 or something no one can read.
No, no, my lords, we've
How
two-type.
can you make a type copy out of it?
My lords, is not disputed. 119. I'm a sick.
I don't understand the order.
My lords.
At page 120.
Yes.
Tell us what is serial number 1?
Serial number 1, my lords. It is ordered that 23 lakhs would be in lump sum. Would be deposited by me.
Either translation is wrong,
My lords.
or our understanding is wrong. Or is this the order?
This is the order, my lords. It's not been disputed.
Order that so and so shall recover rupees 23 lakhs from whom?
I'm sorry, my lords.
Page 120.
My lords,
What is that language?
your
used?
lordships may have page 30 of the government affidavit. It's the same.
Read it.
Yes, yes.
Read the
Ordered
same.
that Pu F. Lal Sonkema SK shall recover 23 lakhs. My lords,
In
it
lump
should have
sum.
been shall be recovered from him.
Then everything goes, the order is wrong.
Yes.
Yes, what is your order? You are saying that he will recover it from someone. Why are you cutting his money?
Yes, Your Lordship. However, this order has not been challenged by
Oh, we
him.
don't need to do. You comply with the order.
Yes.
He
If
will recover.
If he
You will not
complied-
recover.
If he complied with, and
It
that
will be
means,
complied with when he recovers it.
no,
Who
my
are you
lord.
to recover?
They recover, they make a recovery from his salary.
Where is the
Deduction from
direction?
his salary.
Where is the direction? Direction is that he will recover.
This is a typing mistake, Your Lordship.
He will recover.
Even the counsel for the appellant just recognizes today only. So actually, this is a typing mistake.
Okay, to a lower stage in the time scale of pay.
Yes.
To a lower stage. What lower stage? 1 stage, 2 stage, 3 stage? How much?
My lord is.
How will they do it?
That is for them to, my lords,
Yes.
answer, my lords.
How have you implemented part 2 of the order?
Part 2. It is therefore ordered that the pay of Pu F. Lal Sonkema SK be reduced to a lower stage in the time scale
Ah,
of pay with
with cumulative effect. Now you will go back one stage, 2 stage, 3 stage. How many stages will you go down?
Yes, as I
From the
already.
stage of so and so to a stage of so and so has to be, this order has to go.
Yes, Your Lordship, as I have already stated that this order has not been challenged till now.
We can take judicial notice of it. It's
Instead
how
of-
much was recovered?
It was already recovered 6 lakhs.
My lords, in their counter at paragraph, my lords,
6 lakhs 67,290 rupees has
Paragraph
already
9.
been recovered.
I'm sorry, paragraph 9 of their counter affidavit, my lords.
Paragraph 9.
Yes, page 5. Government.
Paragraph 9. Yes, have you calculated what is his dues on his demise? What the family is supposed to be
Yes, Your
given?
Lordship, it is written that the balance is 36 lakhs.
No. When he dies, his families, if there was no such punishment, there would be some amount to the family.
I
What is that
understand.
amount?
No, we haven't made their calculation.
You may not
I
have
have to
paid
take
the
this
amount, but
one,
you have calculated.
Yes, Your Lordship, I will take the
Where
instruction.
is that calculation?
I don't have at the moment. I have to.
Suppose you owe him 70 lakhs. You can recover 40 lakhs. Give him the 30 first.
Yes.
Then we will decide what to do
Your
with the
Lordship, in
40.
that regard, what I would like to mention.
Or if you owe him 10 lakhs, you want to recover 40 lakhs.
Your Lordship, if I may take you to the petition of the applicant, that is in page 103, that is the letter supplied to the Chief Controller of Accounts by
Page
the
30?
Deputy Director, page 103.
103, yes.
Here, Your Lordship, I believe that this makes clear that the amount, there is no such amount which they can receive because
Oh, you have to tell us.
because
You have to tell whether he is entitled to family pension or not. He must be. Yes. Now the family pension is not the service holder's money.
I
It is the
understand.
family's money.
Yes,
You cannot stop that.
this is the retirement benefits.
No. Retail benefit is his pension. His pension is his benefit. When he dies, family gets money not because he earned it, but because the family was his family.
Yes,
So that family's money is not your money.
exactly. But
Yes.
however, Your Lordship, as
How can you
part of-
recover from the family pension? Cannot. You can recover from his DCRG.
Yes,
You can recover from his GPF. You
yes.
can recover from so many things.
yes,
Now, in your own order, you said we will recover it in installments. Yes?
yes.
Take an undertaking from them that we will pay it in installments. Give them the money, take back our installments. But can you stop everything, madam? This you cannot do, and not with that kind of an order. An order where one of the most learned disciplinary authority is writing, he will recover. Let him go and recover then. He's saying reduce time scale of pay. By what? 1 stage, 2 stage, 1 increment, 2 increment, what? What was he? Chowkidar?
No, my lord, storekeeper.
Storekeeper.
Yes,
Group C.
Storekeeper, in your order, you have not said that you gave him an inquiry report. You did not say that he was allowed an opportunity. Nothing is there. Poor fellow did not challenge it. You would not have recovered 1 paisa from him.
My lords, there's one small question, my lords, I pose to myself is that
See, sir, we will not be able to dispose of your petition today for only one thing. we do not have these specific amounts which are due to you. Once we have that amount, since there was no challenge to the recovery,
Yes.
we'll have to modulate out a way as to how that amount has to be paid back to the government. We will not let the government exchequer suffer. So,
But my lords, my only question is, I put this question to myself, is that, my lords, can pecuniary loss, this recovery be made when there is no order being passed under the rules?
see, they, on that ground, we can say that yes, since the order does not indicate that on the date what will happen, and therefore now the order becomes a defunct order. That will be one way of looking at it. But then, does any order say what happens when a person dies in service and he is imposed with a punishment? It does not.
No, no.
It's a matter of recovery.
Yes.
Recovery has to be from his earnings.
Yes.
Yes. So the salary part, they were withdrawing, he was agreeable to it. So we will take it to be a deemed admission that that money was required to be recovered. Now, we are of the mind that family pension is the family's money, not his money.
Yes, yes, yes.
So the pension has to come. Now, what arises out of his death? Or let us say on his termination of service, what would arise? The GPF amount.
Yes.
That is a provident amount, provident fund.
Yes.
Cannot be touched.
Yes.
Give us arguments on those lines, sir. It's a provident fund.
Correct.
You cannot touch it. It has to go to my family. It was for my family's providence.
My lords, the insurance.
Then the insurance part, it has to go back to you.
Yes.
Then what only remains is the DCRG. The death cum retirement gratuity. They would say that, okay, you were under a punishment. We are not grateful to you. No gratuity.
Yes, yes.
We'll take it back as recovery.
Yes.
Maybe. We don't know.
And
But again, it is only on death that that money has become due. Once the person dies, it is your money,
Yes.
not the government's money. Yes, madam. We'll take this up on the 3rd of August
Yes,
or
Your
4th of August. We will keep it as part heard. And yes, sir.
Well, I would like to submit to your lordship the one.
Please.
I've been waiting for my pension for the past more than 10 years, my lord.
Huh?
My husband, deceased government servant, died in the year 2016. Since then, I've been waiting for my pension, my lord.
Are you on opposite sides?
My lords,
He is the daughter of the earlier marriage. I am the wife of
my lords,
So you are supporting him?
he supports.
Yes, my lord.
It's just that I had
Actually,
filed
Your
it.
Lordship, at the
Yeah,
beginning, they
madam,
were not, they
what
were
do you
not supporting
what
each
do you
other.
say? You are cornered.
There was issue between them, but during the
No, that
in
means
the
so.
meantime-
If the wife is alive, no family pension to any other person.
Yes.
That is how we understand it. Give it to her.
That is true.
Give it to her. Give the family pension. Let them fight. They'll fight at home. How much to get? But you give it to her. And I don't think they are going to fight. There'll be enough and more for them to come to a compromise.
10 years is too long, my lord.
So when are you doing it? The family pension part, when are you doing it?
We try to manage ourselves by earning something somehow on a daily
No,
basis.
I'm asking madam.
Yes.
3rd of August? Family pension to be paid by then? Or at least calculated? Huh?
Yes.
We will not write down a very long order. We are also in a hurry. We will trust your memory on that. So what we want to know is the amount that is supposed to be given to the petitioners and the respondent number 7, family of the deceased employee, if there was no order of recovery. Number 1. Detailed breakup.
Yes.
As per the prayers. You see, he has given DCRG, EPF, this, that, this. And the progress in the family pension processing to the wife
Yes.
of the deceased employee. Yes.
My lords, if the directions could be spelled out, my lords.
Huh?
If the direction.
We'll trust her memory. You are here on the 3rd, madam. We would not like to ask someone else again.
My lords, I'm only saying this because my lords, petitioner number 2, who is also one of the nominees for the other benefits, she's 97, my lords, mother of the deceased officer.
Oh, the mother and the wife.
Yes. He may
Heard
not.
Mr. Swenso, learned counsel is paying for the petitioner. Also heard Ms. Swenso, learned counsel is paying for all the respondent, for
State respondent.
1 to 6.
for the state respondent 1 to 6.
I'm for 7 and 8.
7 and 8. Mr. Swenso, learned senior counsel assisted by appears for the respondent number 7 and 8. The petitioner is the mother of a deceased employee and the respondent.
My lords, petitioner, my lords, we are the legal heirs. If that, my lords, we're all here. All the children are the petitioners along with the mother. The mother of the deceased.
The petitioners are the mother of the deceased and children of the deceased employee, respectively, while the respondent number 7 is the wife.
Second wife.
Is the second wife, and respondent number 8
Is the granddaughter of the second wife.
is the granddaughter of the second wife of the deceased employee. Full stop. The Learned Counsel appearing for the state has assured this court that on the next date of listing, the respondents would place before this court the calculation of the death cum retrial benefits which would have been available to the deceased employee in the which would have been available to the family of the deceased employee, in the event there was no order of recovery against the deceased employee. Full stop. The Learned Counsel has also assured this court that she would have appropriate instructions on the stage of processing the family pension arising out of the death of the deceased employee on the next date fixed. Full stop. List on the 4th of August 2026 as a part heard matter.
My lords, if that could be added, that children along with the first wife is also in petition.
The petitioners are the mother, the first wife, and the children respectively. Okay. We'll have it heard. You.
Yes, Your Lordship, in that regard, do I need to file by way of affidavit
That
or?
would be best.
If you file an affidavit, we'll have it on record the night before so that we can go through it.
Yes.
Or if you give it to us in the court, then someone else will miss a hearing. We'll go through it page by page.
It's better to file affidavit.
Because if you say affidavit, then again on the next day, deponent was not here, appropriate instructions not here. Better give it us on a piece of paper, we'll see. Yes, how many more?
Obliged.
Any more on the hearing list to be done? No. Anybody else wants to do? Which one is it? List on the due to positive time, list on the week comments. In this matter, what is the item number? Due to positive time, list the matter. Or can we have it tomorrow? Tomorrow we'll pass the order. Tomorrow. We'll pass it tomorrow.
Lordship,
Yes.
My Lord, item number 6, I'm for the respondent.
6 of?
Part 2.
Part 2, huh?
Lordship, with the consent of the other party, if this matter may be taken up again on 20 of July.
Allowed. At the request of the Learned Counsel appearing for the parties, list the matter again on the 20 July 2026.
Yes, Lordship. Obliged.
Yes, sir. PP, you have not informed the PP.
Yes, my lord, I could not found her, my lord, there. Therefore, only my lord, I am paying CD, my lord. It is regular bail and DPS commercial quantity, my lord.
This is an application. Heard Mr. A.M. Borbunia, Learned Counsel appearing for the petitioner. Full stop. This is an application paying for bail. At page 1, you will find her. So-and-so. Ms. So-and-so appears for the state. Full stop. Call for the trial court record, scan copy of the trial court records. Charge sheet. Call for the scan copy of the trial court records. List again on 23rd of July.
My lord.
It is a Thursday. When do you want it?
Thursday.
Thursday. 23rd of July
Or
2026.
my lord, may it be Friday, my lord. Right.
On the 24th of July 2026.
I'm giving you my lord.
Thank you. Thank you.